Good afternoon, Shamji. How are you?
I'm good. Okay. So I just have one request to all the speakers, panelists, and also the coordinators can also take note of this. We had suffered slight disruption, and the main reason is this is a browser-based platform, and there are two controls on the top right, which is pause and stop. So please, and these controls are visible only to the speakers. तो अगर whenever you want to exit, just close the browser. क्योंकि वो जो stop button is to close the session and it automatically logs out all the speakers and all the participants. So, we don't need to touch those controls, pause and stop or recording. We just, if after the session, if anybody wants to leave, they can just close the browser. That will be fine. Otherwise, but जो नीचे सामने आपके पास तीन buttons हैं, this is mic and camera, and the red one is for both. तो इसमें stop button ऐसा और कोई नहीं है. That is probably one inconvenient thing. So I will request the student coordinators also, please make this announcement in every session at the starting. सर राजेश जी आपका माइक म्यूट है अभी.
This is all right now?
Perfect.
Yes, sir.
Okay. It means 3 of the buttons which are red buttons on the top, including stop recording, should not be touched by any of the participants. That is the signal you are giving.
Thank you. Sir. Request, humble request.
Okay. And whatever we can touch is those in the
3 buttons at the
bottom panel, where we have turn off camera, turn off mute audio, and stop audio and video both.
Yes, sir.
During the continuance of session, even these 3 are not required at this stage.
Only thing is
one can use it.
Just only to have a better audio content. When one person is speaking, then the others can keep mute. But if there is a panel discussion, then everybody can certainly join in.
So we should not be fiddling with buttons too much. That is what you are
perfect, sir.
Top buttons will invoke contempt of IT.
Okay, over to you, Akant, now.
Yes, sir.
The session is on.
Good afternoon, everyone. Thank you for joining in. I'm Ayushi Roy, and I welcome you all to today's session on corporate liquidations on behalf of the Center for Transnational Commercial Law, National Law University, Delhi. In line with today's theme of insolvency resolutions promoting entrepreneurship post the pandemic, our panel will be discussing certain key issues in corporate liquidations. On our panel of speakers, we have with us today Shri Rajesh Sharma, Honorable Member of the NCLT, who will be chairing today's session. Mr. Sharma is presently serving as a member of the Mumbai bench of National Company Law Tribunal, and he has over 30 years of experience in finance, term lending, and investment banking, management, investment promotion, accounting, and taxation. As the next speaker, we have Shri Ritesh Kavriya, who is currently an Executive Director at the Insolvency and Bankruptcy Board of India. He has also served as a Director at the Department of Telecom and the Ministry of Defense, and holds a Master's in Public Administration from the Syracuse University. On our panel, we also have Shri Anup Rawat, Equity Partner in the Insolvency and Bankruptcy practice at Shardul Amanchal Mangaldas & Co. He has over 15 years of experience, and his focus areas include insolvency and bankruptcy, projects, banking, and finance. He has also been instrumental in various notable cases and has represented prominent companies like Bhushan Steel, among others. As our final speaker, we have Shri Ravi Sharma, who is a managing partner at RSM & Co. Company Secretaries. He has been a company secretary and insolvency professional for over 20 years and regularly appears before the Authority for Advanced Ruling, various benches of the Income Tax Appellate Tribunal and NCLT across the country, and has over 17 years of experience in this industry. As the moderator for today's session, we have Advocate Akant Kumar Mittal, who has been a practicing lawyer for the past 4 years, based primarily in Delhi and Chandigarh. He specializes in insolvency and bankruptcy law practice in India. He has also authored a commentary titled Insolvency and Bankruptcy Law and Practice, which was launched on 12 December 2020. He completed his BA LLB from National Law University, Delhi in 2015. We are honored to have this esteemed panel with us today, and I thank you all for joining in. Before we start, I will briefly introduce the schedule for today's session. We'll start with an address by Advocate Akant Kumar Mittal, who will be moderating this session. Then followed by opening remarks by the chairperson, Honorable Member of NCLT, Mr. Rajesh Sharma, followed by the address by Mr. Ritesh Kavriya, followed by the address by Shri Anup Dawat, and finally the address by Shri Ravi Sharma, post which the chairperson will be opening the floor for questions from the audience as well as the moderator. We'll start with Mr. Akant Mittal giving a brief on the topic of corporate liquidation. Over to you, sir.
Thank you, Ms. Ayushi. Members of the esteemed panel and the audience, welcome and good afternoon. And first of all, I would like to express my gratitude towards Risham sir. He has been my mentor, and right from the law school days, even till now, I have always deferred to his opinion on this area of law, and he has been one of the foremost leading scholars in this field in India. And congratulations, sir, for holding this gigantic and mammoth of a task of holding this symposium together. I wish you all the best. Starting with the topic at hand, the session is on liquidation under IBC. Liquidation, the process in the words of Supreme Court, the preamble of the IB Code does not even mention the term liquidation. The idea behind liquidation has been termed in the opinion of the Supreme Court as a matter of last resort, wherein there is nothing that could be done to salvage the ailing corporate debtor. The topic at hand presents numerous opportunities for the panelists to deal with, as well as it is one of the toughest phases of the insolvency bankruptcy code, because a lot of these companies, by the time they run into liquidation, there is hardly anything to recover from. For instance, if we just compare the success story of IB code, then the primary examples would be of Bhushan Steel, where the debt was 56,000 crores, but the amount realized during the CIRP process was 35,000 crores. Then there was SR Steel, the amount due was 49,000 crores. The amount realized during the CIRP process was 42,000. Now contrast this with liquidation process, where there are cases where there has nothing been recovered from the corporate debtor. For instance, in the case Gotaranga Minerals, where the amount was to the tune of 4,662 crores and nothing was recovered in liquidation. Similarly, the case of Abhyam Trading, where the amount was 11 crores, nothing was salvaged except for 85 lakhs. Clearly, liquidation is one of the toughest phases of IB code, and a lot of issues have kept coming up right from the practitioners, be it insolvency professionals, right till the other stakeholders. There have been various conflicts with other statutory laws, and liquidators have found it difficult to cope up with the expenses that have piled up till that stage. We are keeping that in mind, and the interest of various stakeholders involved into this process. We will be conducting this session primarily focusing on two major issues, along with other issues that may come up in various addresses. One of the issues is selling the corporate debtor as a going concern during the stage of liquidation. And second is the tax issues that have come up during the liquidation process. I request Honorable Member Shri Rajesh Sharma to give his opening remarks on this. Sir.
Good afternoon, my co-panelists and participants. The number of people who are participating here shows that what level of interest the topic is having in the area of IBC 2016. You see, first of all, I would like to get excused from the panel and participants. You see, as part of my job profile, day in and day out, I have been dealing with sections and cases. So I just would like to have some fresh air, and I'll be keeping myself aloof from sections and cases. Okay, and I'll request my co-panelists to take care of those things. I'll be intervening in between whenever I feel that some intervention is required from my side, or most of the time I'll be dealing the softer part of it rather than sections, cases, and case laws. Hopefully, that can be allowed by my co-panelists. Okay. Now as far as this liquidation as a going concern and tax issues are concerned, you see a very relevant corollary can be made from a person who is sick. Somebody who is hospitalized, you tried your best, he is kith and kin of yours, you tried your best to survive him by the way of resolution. As a matter of fact, the buzzword of IBC is only resolution, resolution, and resolution, nothing else. But you see, you tried your best, you tried everything, but you could not make him survive. Now, what you do is, it's like liquidation, dead body, you need to take them to the final rites and all that. When you say liquidation as a going concern, it is like salvaging some of the organs of a dead person, taking them out and using it for somebody else. This is how I take liquidation as a going concern in the human form. Similarly, on tax issues, you see there have been debates, and I believe one of my co-panelists will be taking up the issue of tax-related matters of liquidation during liquidation period. Hopefully, with these lines, I'll end my opening remarks here. The floor is with Akan to
Thank you, sir.
Yes.
Thank you, sir. And as very rightly pointed out, it is like a dead person trying to get as much as possible out of it. And keeping in mind this, I would request Shri Kavadia to kindly take the floor and address. Sir.
Thank you, Akant, and good afternoon, my panelists, co-panelists, and attendees of this session. As Justice has already told, the focus of the code is on the resolution. But this topic for this session is liquidation. And when I say that the focus of the code is on resolution, it is to say that the code provides for initiation of a process for CRP, corporate insolvency resolution process. It does not allow for direct initiation of liquidation. Means our statute requires us to explore the possibility of resolution first. Default of a certain threshold amount can land a company into insolvency, but that does not imply that the firm has failed or the firm has become unviable. This decision is a complex decision that has many aspects to be considered before deciding whether a company is viable or not. This is a complex commercial decision and it has been entrusted on the committee of creditors. And this decision is arrived at by the market mechanism. When I say market, suppose a COC wants resolution, but because of certain reasons, no resolution applicant can come and submit a resolution plan. So then what? The company will go into liquidation despite COC willing to resolve it. This question is more relevant in the present case situation where whole the economy is under stress due to global pandemic of COVID-19. Even otherwise, the market may end up wrongly punishing a viable firm and putting it into liquidation, and vice versa. So market can err on both sides. But if it's errs and rescues a unviable firm, this error will again creep surface out. The firm will eventually close out because this firm is not viable on the first stage. But on the other side, if a viable firm is liquidated, sent to liquidation for any reasons, be it unavailability of resolution applicant, non-proper application by COC, any other reason, then this loss is irreversible. This enterprise capital will be lost, and the stakeholders who rely on this corporate debtor for their daily bread will be seriously hampered. So based on this code has adopted a very cautious approach and provides an opportunity to the market to rectify mistake whenever they come across that they have made a mistakes. Even after a CRP is initiated, the market discovers that the process should not have been started. It provides a mechanism for withdrawal of the process by under Section 12A by 90% of voting power of COC. During the process, the stakeholders endeavor and try to resolve this company through a resolution plan. And even after this, they conclude that this firm is not viable. They send it for liquidation. This again, during the liquidation process, there are provisions to again try to resolve or at least save some enterprise capital of the company. All this process is supplemented by a provision that COC can at any time decide to liquidate the corporate debtor, so that the CRP process of an unviable company where this is unviable on the face of it is not dragged on the CRP process for long. So this is a very fine sort of policy discourse where you don't go for liquidation directly, but you have enough flexibility with the market to decide whatever is right. So even after the order of liquidation is passed, law enables the compromise or arrangement based on an application by a member, creditor, or liquidator. In our in some cases, even NCLAT has directed to attempt for compromise or arrangement. We have a provision for sale as a going concern in our regulations. On many occasions, even NCLT has ordered us to the liquidator to explore sale as a going concern. And if everything fails, then as a last option, the liquidator has to proceed to sell the assets in bits and pieces and completely liquidate the assets. With all this focus on resolutions, the code has been fairly successful in preserving the value of the assets. In value terms, this code has been able to save most of the value that has come on its door. Around 20,000 applications so far have been disposed of by the NCLT, and of this 80% have been withdrawn even before admission. And of the 4,000 sort of application which entered into this insolvency, around 1,200 CDs were resolved either by approval of resolution plans on 308 cases, and another 900 by review, appeal, or withdrawals under Section 12A. So in that, around 1,100 companies ended up in liquidation, which is around 5% of the companies that landed at the doors of NCLT. So that's a remarkable feat for the code, and it's my duty to mention that NCLT, NCLAT, and judiciary have been in the forefront of the implementation of this code. They are the referee of this whole match. Everything happens under their supervision. They have settled several conceptual and contentious issues swiftly while imparting clarity on many roles of various stakeholders in the resolution process. They have delivered some landmark orders. They provided clarity on what is permissible, what is not permissible, and streamlined the process. And on many occasions, they have guided us to make some policy changes or regulatory changes. Even the Supreme Court of India has been deciding matters in the matters of days while in disposing the cases on insolvency. This insolvency is probably one of the largest body of case laws in India right now. On our website alone, we have more than 13,000 orders on this code. So in a very short span of time, on a new law, such a large body of orders by a new body, NCLT is a new body. It was created in 2016 only. That is a remarkable feat, and due credit must be given to NCLT for successful implementation of this code. As I told, that more than 1,000 liquidation cases are ongoing, and this number may seem large, but we have to be aware of the fact that most of these are legacy cases. Around 75% of the cases are such where the companies were either defunct or they were not run as a going concern. So as Ekant mentioned in his address, Gotaringa, Orchid Pharma, some cases where a large amount of claims were there, but as such nothing, absolutely no asset was there on the paper. So nothing was there to be liquidated. So all these liquidation cases, 1,000 liquidation cases, around they have liquidation value of around 43,000 crore, which is small if I compare it with the resolutions that this code has been able to achieve, which is around 2 lakh crore. But on a standalone basis, even this amount is not short, and we must have every endeavor to see life, enterprise capital or assets of the corporate debtor in the way we can. Coming to the sale of the going concern, Section 32 of the Regulation 32 of the liquidation regulations provides for sale of corporate debtor as a going concern or the business of the corporate debtor as a going concern, which we inserted some on two instances. One is March 2018 and second was October 2018. So there are inherent benefits of the corporate debtor if the corporate debtor or its business can be saved, because it can only be sold if there is some enterprise values left in it. And when it is sold as a going concern, it implies that the market made a wrong decision at the time of CRP process, and that enterprise value was left. And if it is sold as a going concern, it will benefit in many ways. It will preserve the employment of the employees, will preserve the enterprise capital for the economy. It will benefit the trade creditors that are dependent on this company that is saved, or it will, in the long term, it can even provide some revenue to the government in the form of taxes by way of operations of the corporate debtor. The focus of code on resolution cannot be overemphasized. Supreme Court in many landmark judgments have overemphasized that the primary objective of the code is to rescue the lives of the corporate debtor. In the same spirit, we have provided this provision in the code. Till date, 4 corporate debtors have been sold as a going concern, where the liquidation value was 60 crore combined liquidation value, but liquidator could realize around 81 crore out of this sale as a going concern. So that is 35% more than the liquidation value of these firms. So obviously some saving of enterprise value is there, apart from benefit of stakeholders in rescuing the life of the corporate debtor. In one case, Honorable NCLT has dismissed an application for sale as a going concern. That order has been stayed by NCLT on the application of the liquidator. So the matter is sub judice as of now. To conclude, I would say that market may make a mistake to classify a viable CD as unviable, but we must make every effort to see what is right for the economy, what is right for us, and every effort should be made to sell business of the CD or the CD as a going concern. I mentioned that there may be imperfections in the market system, but as a regulator, we have some responsibility towards it also. And the code is in the stages of evolution, we are in evolution phase. This ecology is getting developed. For a perfect market to function, there must be large number of participants, large number of sellers and buyers. There must be perfect information among the stakeholders, and the cost of transactions must be very low. These conditions are not achieved easily, and but we have been attempting to harness the use of information technology to provide a digital marketplace where the transactions can be done electronically, both during CIRP for inviting resolution plans or arranging interim finance, and during liquidation for selling assets. I'm happy to share that we have been successful to some extent in this endeavor, and very soon we will have two platform for distress assets operational, which will be available for resolution professionals and liquidators to invite resolution plans, seek interim finance, and sell assets during liquidation. I hope that this endeavor will increase the pool of resolution applicants and buyers in insolvency cases. It can attract and enable participation from investors across the globe in such assets. As a result, the stakeholders will get maximum value and the cost of transactions will be minimized. And most importantly, some of the viable firms will be rescued because of increase of resolution applicants. I have this much to say right now. I must thank National Law University for arranging this symposium on IBC 2016. Thank you.
Thank you, Sri Kavadia, for your address, and very rightly mentioned that the IBBI is to keep pace with the changes that are taking place. To that extent, there was one question that we wanted to ask, that whether the amendment that took place in July of 2019, the amendment was reducing the liquidation time process to 1 year. Earlier, the time frame to conclude the liquidation was 2 years, but then there was this amendment by the IBBI in its regulations of liquidation. Do you think that the intended goal has been achieved so far? Because there is an exception clause also in case the liquidator is not able to conclude the process by 1 year, it has to make an application before the adjudicating authority seeking extension. What are your views on that, sir?
So basically, our approach from the policy point of view was, first we created a table in the liquidation regulations where the liquidator's fee is more if he is able to realize the assets early. So if the percentage decreases if the realization or recovery and distribution is late. So there is incentive with the liquidators to liquidate it as early as possible. So that was the first attempt that we did in the initial time when we first formed the regulations. But the problem is that during CRP, we can say that the CRP will go on for 180 days, 270 days, and after that, if it does not resolve, it can go to liquidation. But in liquidation, there is nothing can be done. any issues that crop up has to be resolved so that ultimately this final dissolution can be achieved. We are constantly contacting liquidators, trying to assess what are the problems on this aspect. We have addressed some issues, like we allowed sale of non-readily realizable assets. We are constantly taking up within tax authorities, so that the problems that the liquidators are facing, even this buffet, we are working on something for this buffet applications. We have even allowed this buffet applications to be transferred. So we are constantly trying to address those issues, and at the same time we are pushing liquidators to uh, close the liquidation processes as early as possible in the spirit of the code. Uh, as such, it's not possible to define a liquidation process to a particular timeline, because after that, what has to be done? But the constant pressure is there in terms of policy and in terms of regulation. At the end of 1 year, the liquidator will have to approach A, and he has to explain why there is delay. And till now, around 180 cases have been dissolved, and the timeline for them has been 380 days or sort, around 1 year. So at least this framework has done much better than the earlier regimes, where it was in the hands of some officials which were not interested, or which were not having an incentive to early liquidate a company.
Indeed, sir. And on this point, there was a statistic that had come up that out of 587 companies that were under liquidation till 1920, till 2019, out of that, 427 companies were under BIFER. So that certainly makes the job difficult for the policymakers to come up with a proper law that could be equally effective and efficacious. As rightly, just a quick follow-up on that, the situation post-COVID, once the moratorium is lifted, how do you see the companies, if there is going to be a flux of cases coming under resolution, how do you see the liquidation process? Is it strong enough to hold that?
Once this COVID moratorium is lifted, the government is very much alive to the fact that the economy is under distress, and this COVID period default have been excluded forever. So the companies which went into distress for some time, they will be able to recoup, and this default will be out of insolvency. The momentary defaults, if any, will be out of insolvency forever. The limit for initiation of insolvency has been enhanced. So as such, we don't anticipate large number of cases entering into insolvency right now, even just after lifting of moratorium. Now, market in itself has been trying on various alternate mechanisms. Remember, this use of this code is not mandatory. People can very well resolve their issues outside the code. It's only purely optional. So economy has not stopped. People have not stopped. They are trying to resolve distress through alternate mechanisms, bilateral negotiation, RBI framework. So, for the smaller companies, the FM had announced a special insolvency resolution framework. We hope that it will be rolled out soon. So I don't foresee many companies entering into CIRP. But your question was regarding liquidation. So, but liquidation, there is no procedure for direct liquidation. So only the companies that enter into insolvency can go for liquidation. So
Thank you.
No.
Thank you, sir, for your time and your very pertinent views on this issue, which I am a lot of queries have been received on this to this regard, and thank you for answering that. Now I again request Advocate Anup Rawat. So please kindly take the floor and for your address.
But Ekant, just a moment. As I briefed you, I have some urgent issue attended,
Indeed.
and I will be seeking leave of this panel.
Indeed.
I would have loved to listen to you all, but unfortunately, some pressing issues are there. Loss is all mine. Once again, thank you, NLU. Thank you, all the panelists. Thank you,
It
sir.
was an enlightening experience, sir, to converse here, and for the audience also to hear from the policymakers. It has to be this actively involved into this process. It is really an honor that you could spare this much time. Thank you, sir, and wish you a great day ahead.
Thank you.
Thank you. Thank you, Akant. And, good afternoon to the learned
एक
panelists and
सेकंड
the member.
राजेश सर कुछ बोलना चाह रहे हैं.
Yes. Before Mr. Anup Rawat starts, I would like to make a few quick comments about the period of COVID and how NCLT has tried to tackle and work during the COVID period. You see, during the entire lockdown period, NCLT did not stop working even for a single day. From day one, our special benches were working. Our president's principal bench was taking up matter of the entire country. There was a special bench for taking up companies, merger and acquisition cases, 232 to 232 in Mumbai. There was a special bench for taking up 252 cases in Mumbai. And during the period from March to July, we got the fresh applications of about 800 or so. And the disposal was 2,500 cases. 3 times of the cases which were received fresh, the disposal was 3 times of that. Our few members got COVID during that period, about 4 or 5, including myself. But most of them were working from home and disposing of the case. I did not take even a single day leave during that period of COVID. My 3 colleagues were struggling for their life in hospitals. One of our joint registrar succumbed to COVID. Still, NCLT continued functioning during the entire period. And I have not seen even a single case where somebody has said that my case is urgent, it will be heard, and it was repeated. So this is how the functioning of NCLT is in the entire country. And if somebody asks for any urgent hearing, he is given the opportunity. So this is what I just wanted to tell about NCLT.
Thank you, sir. And this is certainly one of the moments where the judiciary has stepped up. And in my personal experience also, we have filed numerous applications on behalf of our clients who have been regularly asking us that our matter is not getting, it keeps getting adjourned. And whenever we have filed an application for early hearing, we have been given a prompt hearing. To that effect, we are really thankful and really sorry to hear about the joint registrar. And all we can say is the effort that is being put by various stakeholders during this entire testing phase, it will certainly bear its fruits. With that, I may request Mr. Rawat, please kindly take the floor for your address.
Okay, thank you.
Topic today for this panel is sale of the company as a going concern during the liquidation period. Now, I want to go back to 2016 and the start of 2017 when the implementation started. This whole process was considered as a one-way street. Everybody understood the whole code as a platform where resolution has to happen within a limited time period, and if it doesn't happen, then it has to meet its death. The company has to die. It has to go into the liquidation. It has to be stripped off, as the honorable member said, that the organ have to be given away. and rightly so, because the focus was not only on revival but also on the timely revival. In fact, it is enshrined in the preamble to the code itself that it has to be a timely revival. Because if the timely revival doesn't happen, then the value loss happens and the rotation of the capital doesn't take place. But what has happened, we have seen in many cases that even the companies which could be run as a going concern, even they could not get resolution in some of the cases and they reached the stage of liquidation. It was very difficult to accept that a company which is operating and which is sustaining the livelihood of a lot of employees, workers, the suppliers or the service providers who interact with the company, they will also have to suffer. And therefore, the concept of sale of the company as a going concern was also introduced. While this concept does help in the revival, but one word of caution I want to put here is that it should not become a device for deliberately bringing the company to a stage of liquidation and then it's being sold as a going concern. And that is something which was actually not intended when the code was enacted. Now, there are a couple of things which needs to be considered while discussing this particular issue of sale as a going concern. As to one question is that why does it happen? Why is that a company which can be operated? Why is that there is no resolution during the insolvency resolution process? And why there is a sale as a going concern in the liquidation? What happens in the liquidation process that some bidder suddenly comes and says that now I want to take it as a going concern, I want to run it, and he doesn't come during the resolution process? That's a very, very important study that needs to be conducted. What I could feel, what could be the potential reason? One reason which as a practitioner I thought is that when the lenders look at the resolution plans during the resolution period, they always compare it with the liquidation value. Invariably, this is what has been done, irrespective of how much we say that it's a holistic approach. Nobody should look at the recovery. It is not a recovery platform. But the fact of the matter is that all the creditors look at the resolution plan, compare it with the liquidation value. Now, what is this liquidation value that they look at? The regulation has rightly provided that there has to be liquidation value, which needs to be determined from a perspective of giving guidance to the lenders of arriving at a decision. But unfortunately, the liquidation value has become a reason for failure of some of the resolution plans. And the one reason is the unrealistic timeline cutoff date on which the liquidation value gets determined in the first place. If you look at the regulation today, the liquidation value gets determined on the insolvency commencement date, which means when the company actually admitted to the insolvency process. Now, that is not the point of time that the value has actually gone down or some of the assets of the corporator have deteriorated. What happens in the resolution process? And most of the times we have seen that it is a process which runs to 6 to 8 months minimum. What happens during this process? Your stock, which were available on the insolvency commencement date, that gets exhausted. It gets utilized in the process. There may not be a replenishment because the interim funding doesn't come during this period. There could be deterioration naturally on account of lowering of or reduction in the concession period or the licensing period. There could be natural wear and tear, and then fourth could be the deterioration because of the mishandling. Now, of course, mishandling is something which goes right to the duties of the resolution professional, because he has a duty to preserve the asset. So if the preservation has not happened, then our obligation can be fixed. But for other three reasons, you cannot avoid it. It's a natural process. the value will go down. So when the plan actually comes to the lenders, let us say 8 to 10 months or a year down the line, and when they look at that plan actually reflects the true value of the enterprise at that point of time. It may not be the actual liquidation value which is being thought would be the liquidation value as on the insolvency commencement date. And that is very true for manufacturing concerns, where the stock level on the insolvency commencement date may be huge but got exhausted, got sold. Now, when the lenders look at the resolution plan 1 year down the line, and when they look at it, and in some of the cases the value is not equivalent to the liquidation value as on the insolvency commencement date, they tend to reject it. Now, the rejection is not because the lenders feel that that's not the right value, but because of the inherent the system, the process which has been created within the lender community, that they peg it to the liquidation value and then they decide. And in some of the cases, the company actually has gone into liquidation because of that reason. Now, what happens in the liquidation phase then? The liquidator again calculates the liquidation value, and this time it is the reflection of a right value. And this time perhaps it is maybe 30% or 40% lower than the liquidation value on the insolvency commencement date. And now when the plan comes and somebody says, I want to buy it at that reduced value, lenders may not have any, forget about lenders, even liquidator may not have any issue, and he might present it. So what happens ultimately? You are, losing out on an actual value. If they had calculated the liquidation value on the date when the plans are coming, then perhaps it would have given them the right perspective of whether the plan is correct or not. But that's so I think that is one of the reasons. The second reason are the systemic issues where, the quality of the data, the quality of the information memorandum which is being prepared, that is, substandard. And that one reason for that could be that, the companies were managed poorly. They did not have the governance level. And so therefore, they did not attract good investors. So if you are, and therefore, you did not get a good plan also. And that is true specifically in a regulated sectors. So what happens? No plan comes during the resolution process. And then in the liquidation, somebody actually buys the company at the cheapest rate possible. So I think one examination that needs to be done, and perhaps it could be through intervention of legislature, through IBBI, through judicial intervention, that the reasons why the company has gone into liquidation and why now it is being offered to be sold as a going concern, that must be a mandatory requirement for anybody to for any liquidator to come and propose it before the tribunal, and to see whether there has been deliberate attempts to bring down the value. There have been deliberate withholding of the information from the general investors so that they did not come, and to lead it to the liquidation where the asset will fetch the lowest value possible. It might revive the company, it might save the employment, but there's a huge value loss in all of this. So I think while sale of the company as a going concern during liquidation is a very good concept, it must be looked at and it must be considered only after going through the detailed reasons of why the situation has actually happened, and there should be strict requirement for the liquidator to prove why this is the right thing now, and to explain why it has not happened earlier. I'll give you one example, and the reason why I'm saying it is because we are still at a nascent stage. This law is still evolving. The liquidation regulation is still not clear on a lot of aspects. For example, if a bidder comes in the liquidation phase and says, I want to take the company as a going concern, that would mean he wants the shareholding. Now, there is nothing in the liquidation regulation today to facilitate extinguishment of the existing shares, issuance of the shares to the new person. It is through the judicial activism that these concepts have now come. Now, there are some cases where the NCLTs have very proactively come up with the justifications for allowing sale of the company as a going concern. and allowing the extinguishment of the shares and insurance shares. But I think there has to be a regulatory certainty around it. And that why I'm saying is that especially because the ED also, the learned ED from IBB also mentioned that the principal bench also questioned it. Principal bench also questioned that, if the act, the code itself doesn't have a provision, then how do you in fact force a sale of a company as a going concern? So I think these uncertainties needs to be taken care of. There has to be a strict mechanism of how you allow. Otherwise, the sale of the company as a going concern in liquidation will become a norm. It will keep on driving the value down, and there will be fewer resolutions during the resolution process. So I think we need to fix some of these things, and fixing the liquidation value, I think, is the most important part. Over to you, Akant.
Thank you, Shri Rawat. And there was certainly this point has kept coming up.
I think something.
Thank you, Shri Rawat. Sir, would you want to add on to that?
Yes, that is what.
Yes, sir.
Just supplementing Mr. Anup Rawat's views on the issue of liquidation. One tries his best to get the company resolved during CRP, and if it is not done and it is inevitable, only then one goes for liquidation. I'll cite you an example without naming the case, without naming the product, but the process I would like to cite, and it's an eye-opening for anybody. Sitting at the benches, we are daily dealing almost on daily basis, day in and day out, for CRP and liquidation cases. One fine morning, we get an application for liquidation of the company, duly recommended by COC. I'll take 5 minutes but it's an eye-opening case for everybody. People can learn from this case. We get an application filed by RP stating that the company is to be liquidated. We tried to see that what it is. 4 months back, we had ordered for CRP. Within 4 months, after approval of COC, RP is bringing an application for liquidation of the company. We asked him, why are you in so much hurry of liquidating the company? What happened? They said there is no asset available. We said, fine. You call next time COC people. We would like to discuss with them. We asked them. Next hearing, COC came. We also asked the promoter to come. COC said that only 8.5 crore rupees is the total value of assets which is available, and that to a shop. And there is no other asset available. Promoter said that I want to do the one-time settlement at 55 crore rupees. Now tell us, there is an application before the adjudicating authority with a liquidation value of 8.5 crore, and the promoter is saying that I want to do OTS for 55 crores. And he said that the full facts are not being brought to the before the bench. 80 crore rupees LC, claim of LC for an LC is available with the bank. Now, see, a proposal is coming from COC, which is having, of course, bankers in that, for 8.5 crore rupees liquidation value, where there is an asset value of 80 crore which is not counted by the bank, and 55 crore promoter is ready to give as a OTS. Now, do we accept that type of a liquidation process proposal? You see, none of the bankers was aware, nor the RP, that there is a 80 crore rupees claim which has been received by the banker, other branch of the bank, as a claim for an LC. We asked the promoter that if you are serious in your OTS, deposit immediately rupees 10 crore rupees within 1 week. We'll see your seriousness. 1 week later, promoter came with by depositing 10 crore rupees with the bank. We ordered that this money will not be touched by anybody until unless this bench orders. It should not happen that he deposited 10 crore and bank is taking. But see how callous attitude our COC and RP was having during that. Now tell us, when we say that all the balancing of all the stakeholders is to be done, interest is to be done, feasibility and viability of the project is to be seen. Tell us, as a sitting in on the benches and as an adjudicating authority, if we don't get into details, where we will be heading? You are mute, Mr. Anup Rawat.
I think that's a very important observation that honorable member has made. And I would give the example of other jurisdiction where the bankruptcy courts can go into these kind of questions. And there are many matters in India which requires these kind of interventions. And it's so pleased to know that the honorable bench did that and salvaged that value. So it is required. You need scrutiny, and that scrutiny is definitely.
Do you have any comparison in 8.5 crore and 150 crore rupees asset value? Can you compare these two?
Yeah, so absolutely. I think the time when the liquidation is being sought, I think that is the time to ask questions. In fact, there is a recent order from one of the NCLTs where they have questioned why the resolution professional filed for liquidation, why the value deteriorated from X to minus 40, reduced by 40%. So these questions have been now asked, and it is the right time to bring out detailed processes and the guidelines which needs to be followed by the.
You see, I may sound blunt in saying so, but I am telling you, every stakeholder is having his own interest. COC member is having their own interest in recovery. They have nothing to do with, most of the time, they have nothing to do with revival of the company. They are interested in how much money I am getting out of. If they are getting more in liquidation, they'll immediately ask for liquidation rather than reviving the company. They are financial creditor. They need to basically answer to their authorities that how much money has been given. Promoter is interested that the company should go into liquidation if he didn't want to continue with it. So there are stakeholders who have their own interest. NCLT as an adjudicating authority has to balance all of them and then come out with a solution. Sometimes it happens. Sometimes there are good companies also. It's not that the good people are there. But sometimes this type of situation, which I have done.
And certainly, sir, even in a lot of cases, the NCLT has even stepped in wherever there has been an attempt to circumvent the government dues. There are taxation dues where the plan has been sought, which has basically sought the waiver of all the taxation dues that are there. Even in that case, the NCLT has remarked past observations, and I think in couple of in Chandigarh benches there have been couple of observations that went up till the NCLAT, and the NCLAT had taken note of how the resolution plan was lopsided to that effect. As the theme of the session is also on tax insolvency, I believe Mr. Sharma would also.
One thing more. You will find, you can do complete analysis of this. The biggest hit is taken by the government as far as this resolution process is concerned. The biggest hit. Only all government dues become zero in most of the time. So if you see the sum total of the entire hit, it is the government is the most which has taken the biggest hit in this case.
Certainly, sir. So with that, with your permission, should we maybe request Mr.
Ravi Sharma, we kept you holding for some time.
Mr. Sharma, thank you. Please take the floor. Mr. Sharma, I have to interject. You are not audible right now. Your voice is not coming. Not audible. Still not audible. You are not on mute, but the voice is still not coming. I will ask one of the organizers to assist you with this. Let me. Yes.
Ravika, if you could check the technical arrangements at your end, whether your mic is enabled, because if you're unmuted on the platform, then it might be a technical error on your end.
It's still the same issue? No? Ekant?
Yes, Mr. Sharma. Yes, you are audible now.
That's great. So thank you very much. Good afternoon, everybody. So as I was mentioning, that all the fiscal laws, and in all the fiscal laws, rather the commerciality is more important rather than the law, and law should only be a guiding force, and the commerciality of the transaction and commercial viability should be the deciding factor. Now, my topic today is the tax issues in insolvency, and here I will be discussing the direct tax rather than the indirect one, that is the income tax, and I am going to cover the tax issues vis-a-vis the insolvency code. So I would not be restraining myself only to the liquidation thing. Now, why at all there are issues? So whenever there is a new legislation, there has to be some sort of conflict between the existing laws, and the issue would be bigger if we talk about the fiscal laws. Now, just let me give you an example. Say, for example, the basic understanding of insolvency code is that we have to take promoter out of the company, and now then there is a new person who is supposed to be at the helm of the affairs, who is supposed to run the company. That is a resolution professional. Now, this new incumbent at times, obviously, he is not having the support of the promoters who have the understanding of running the company. At times, this gentleman is not having the support of auditor also and the support of accounting staff as well. So what is happening that this new person who is very new to the company, now he is supposed to do various compliances, but he is not having the support of promoters, support of auditor, and support of accounting staff. Now, in such circumstances, wherein day in, day out, you are supposed to make the compliance, it is quite difficult for you to operate because this is one of your duty to operate this company as a going concern. It means you are supposed to abide by all the legislations and specifically in tax laws, wherein there are a number of compliances. And let me give you one specific example. Now, there is one section 140 in the Income Tax Act, and this section 140 has been amended by virtue of which the RP has got the power to sign the income tax return. Now, if you don't sign and file the income tax return within a certain period, which is the due date, the company would not get the benefit of tax losses, meaning thereby the company would not be able to carry forward the tax losses. Now you don't have the financial ready for the reason that the auditor has already left. You don't have the benefit of accounting staff, so you don't know how to prepare the financial statement. And now the due date is reaching and you are supposed to file the tax return. So what will you do? If you take the unverified accounts and you fill in the figures in the tax return and file it, now this return is supposed to be signed by you and authorized by you and verified by you. It means if you do it without verification, there are penal consequences. And for these penal consequences, as of now, in the Income Tax Act, there is no amendment. So what the RP will do? Now, these are the live issues. These are the open issues, the gray areas, which needs to be addressed because there is a responsibility in all the fiscal laws. Now, with this background, with this understanding, let me start the tax issues in insolvency, and we can move to the second or rather the third slide because I believe that we are short of time, so I will try to wrap it up ASAP. So Akanksha, if we can go to the third slide rather. Yeah, third one. Yeah, right, the third one. The next one, Akanksha. Yeah. So the controversy and rather the most controversial section, I believe that whether section 238 per se, since it has the non-obstante clause, so it would override the tax law or not. That has been addressed by the Honorable Apex Court in the case of Monet Ispat, and the Apex Court observed that due to section 238, the IBC, the Insolvency Code, would override the income tax law. However, in that matter, the specific issue was in respect of the demand. Now, the point is that it has already been observed by the Honorable NCLT, and there is a sufficient jurisprudence available that the dues, the income tax dues, or should I say the crown debt, that is something which is equivalent to operational creditors. So there is a drift, there is a deviation. If we talk about IBC with other laws, here in the list of priority, the crown debt is pretty low. So as far as the demand is concerned, the moment the company goes into insolvency with the insolvency commencement date, when we have the moratorium period, the income tax department cannot press the demand. So the demand would be there. However, the income tax department is supposed to file their claim with the RP only. And therefore, in the case of Monet Ispat, the Honorable Supreme Court observed that as per section 238 of IBC, the Insolvency Code would override the Income Tax Act, and therefore the Income Tax Department, the revenue, cannot press for the demand. Now, if we can move to the next slide, Akanksha. The fourth one. The previous, yeah. So it was third, right. Right. Thank you very much. Now, the issue is that when the revenue is not able to press for the demand, what would be the tax proceeding? Whether the tax proceedings would also be street. Now, this was the issue before NCLT Ahmedabad in the case of Deputy CIT versus Bhuvan Madan, wherein the Income Tax Department filed an application before NCLT that there is a certain timeline and they should be allowed to conduct the assessment proceedings on the return file. To which the NCLT observed that, okay, fine, they can go ahead with the assessment proceeding, they can conduct the assessment proceeding, they can finalize the assessment. However, post assessment, if there is a demand, they cannot press for the demand, and the demand should become a claim before the RP only. So they can go ahead with the assessment proceeding, but cannot press for the demand. That was the intent of NCLT in the case of Bhuvan Madan for Diamond Power Infrastructure Limited. Now, if we can move further, so this was in respect of the assessment proceeding. When we move further and in respect of the appellate proceeding, that is the appellate forum as far as income tax is concerned, which is the Commissioner Appeals and Income Tax Appellate Tribunal, a view has been taken by various tribunals, specifically ITAT, the Income Tax Appellate Tribunal, that if the company has gone into insolvency, in such circumstances, the appeals should be kept in abeyance for the reason that for all those years wherein either the department or the CC is in appeal before the Income Tax Appellate Tribunal, that demand would be a subject matter of claim before the RP. See, for example, tomorrow if there is a resolution and normally we see that there is a waiver in mostly all the plans, there is a waiver as far as government dues is concerned, and that demand is settled, then the appeal would become infructuous. So therefore, the view of appellate authority in the tax proceeding is that if the company has gone into insolvency, then they should keep the appellate proceeding in abeyance. Now, Akansha, if we can move further, I covered this slide number 4th and 5th. Yeah, please move further. Slide 6. Right. Now, during the resolution plan, now what is happening, as my co-panelists have mentioned, that in all circumstances and in all the plans, normally we see that as far as government dues is concerned, the investors, they don't offer anything. Now the issue is that otherwise also the government dues is equivalent to operational creditors, which has been observed by the Honorable NCLT in the case of Synergis Dure Automotive. Now, in such circumstances, is there any recourse available to the income tax department? Because in number of cases, there may be huge demand. See, for example, in the case of Synergies also, if we observe the plan, the demand was around 338 crore, and that was settled for merely 1% or rather less than 1%. That was at 2.58 crore. So as mentioned by the honorable member NCLT also, that this is a total loss as far as government dues is concerned. So therefore, maybe it is a time that while observing and while approving the resolution plan, the NCLT may strictly ask the investors that as far as government dues are concerned, at least there should be some sort of payment. And automatically, this should not be the intention of investors that, okay, fine, we are not going to pay anything to the government as far as government dues are concerned. Like in the case of Ultratech also, the Rajasthan High Court observed that once the resolution plan has been approved, then income tax department or even the indirect tax department, they don't have any recourse, and this plan is something which is binding on the tax department per se. So in nutshell, what is happening that income tax department or the revenue, they don't achieve anything out of it. Now if we can move further. So tax during liquidation. Now, one of the issues is that whenever there is a liquidation, either you can sell the company as a going concern. Now we have the provision, or if you are not able to sell the company as a going concern, you can sell the company as piecemeal. That is, you can sell the assets of the company. Now, when you sell the assets of the company, there has to be some capital gain. Now, when you have the capital gain, there is a tax liability as per the Income Tax Act. Now, the issue is that whether this capital gain tax on sale of assets in liquidation, whether it would become the part of liquidation expense. If it becomes part of liquidation expense, then it would be up in the priority list. Now, if it is not the part of liquidation expense, then it would be treated as operational creditor claim only, low in the priority list. Now, this has been answered by the Honorable NCLT Allahabad in the case of LML Limited, and it has been observed that it would not become part of the liquidation cost, and it can only be recovered in the order of priority specified under section 53. Now, meaning thereby that again at the stage of liquidation, wherein there is a sale of asset and there would be some sort of liability on account of capital gain tax, again the revenue won't be receiving anything out of this demand, and they would be treated as operational creditor only. Again, in the priority list, they would be pretty low. Now, there is another question which has been answered by NCLT, and the question is that whether there would be any tedious liability, and in case if there is a tedious liability, how that should be treated. To which the principal bench NCLT observed in the case of Om Prakash Agrawal that the overriding effect of section 238 is applicable to issue only between the creditor and the debtor and not on the TDS deduction. To which my understanding is that as far as TDS deduction is concerned, though it is a government due, but finally income tax is a tax on income. The primary liability is on the recipient of income. And this TDS is nothing. It is only a secondary liability, only a method to collect tax. But finally, what is happening that you are collecting tax on the income per se. So the treatment should be same. However, the Honorable NCLT principal bench has taken a view that it would not be impacted by section 238. Now, if we can move further. As I mentioned initially also that whenever you have a new legislation, there has to be some sort of dispute, some conflict, and then you need to revise the laws, you need to insert the amendments. So in the Income Tax Act also, we have the amendments, obviously on the basis of experience also whenever there is a conflict. So like in section 79, there was initially issue that in case of carry forward of losses, section 79 of Income Tax Act provides that if the shareholding is not intact, then you won't get the benefit of the carry forward of losses. That has been done away with for the purpose of insolvency. Now, if a new investor is coming in, then he is not supposed to satisfy the condition of section 79 for carry forward of losses as far as insolvency is concerned. Again, there was this issue of signing of return that has been settled by virtue of amending section 140. The RP has got the power to sign the document. That is also an issue that with the signing of document, there are personal liability, which are penal in nature. There may be prosecution also. However, there is no immunity as far as prosecution is concerned in the Income Tax Act. Then again, thirdly, in section 115 JB of the Income Tax Act, which is the MAT provision, there were certain issues which have already been settled. And now even the MAT provision, the company which has gone into insolvency, that would be having the benefit. Now, if we can move further. So there are certain open issues, there are certain gray areas. One is that I have already mentioned the immunity part on account of RP, because RP would be signing number of document and there are penal consequences, the prosecution, etc. Apart from that, again in case of debt waiver, there is a big issue. The point is that the moment the resolution plan is approved, there is a waiver of loan. When you have the waiver of loan as per section 41 of the Income Tax Act, this become a part of your income, the part of the income of corporate debtor. So that should not be the intent, for the reason that in all circumstances the plan which has been approved is binding on the government also. So when I say government, income tax department is part of the government side. So when the plan is binding on you, and due to this plan the operational creditor had to waive certain amount, that should not become part of the income of the corporate debtor, and the corporate debtor should not be asked to pay the tax on that portion. And similar would be the condition with MAT also, because the moment it becomes a part of your financial, that is the waiver amount, it would increase your book profit. And when it would increase the book profit, there would be the tax liability. So again, I believe that is not the desired intention of the code, and there may be amendment as well. Thirdly, the slump sale provision. So when I say slump sale, if you sell the company as an undertaking, as a complete undertaking, lock, stock, and barrel, then there is a tax liability, which may be in the nature of long-term capital gain or the short-term. Now, the point is that even in the liquidation also, we can sell the company as a going concern. And if we sell it as lock, stock, barrel, there may be a issue of the tax liability as slump sale. So that should be addressed. And finally, another issue of liability of directors. So what has happened that section 178 of the Income Tax Act, which is specifically for the purpose of liquidation of companies, and which provides that once a liquidator is appointed, the liquidator is supposed to intimate it to the concerned income tax officer, that is Commissioner Income Tax. And after that, whenever liquidator is supposed to sell the asset, he is supposed to sell the asset with the leave of the commissioner. And if there is some sort of tax liability, the commissioner will notify the amount to the liquidator. Liquidator is supposed to set aside certain amount to satisfy the liability, and then only he can part with the asset. Now that has been done away with in section 178. We have a specific amendment that this would not be applicable in the case of an insolvent company which has gone into insolvency. However, there is section 179 which provides for the liability of directors of the private company. So if a private company is not able to pay the tax dues, then there would be personal liability of directors. Now, there is no amendment as such in section 179 per se, and it seems that the personal liability of the director would be intact till the time they are able to prove that there is no negligence, no gross neglect, no breach of trust on their part. So all these are the open areas, very means gray issues, which I believe that in future all the issues would be addressed. So I would wrap up my session here, and if there are any queries, please let me know.
Thank you, Mr. Sharma. That was very succinct and very thoroughly put. I think you have covered all the issues that are pertaining to direct taxation vis-a-vis its conflict with IB code. We have some of the questions to ask Mr. Rawat and you as well. Mr. Rawat,
Yeah, Kant.
hello. Mr. Rawat, the first question we wanted to ask you was whether, in your opinion, do you think the embargo of Section 29A should be lifted for the purposes of liquidation? During the process of liquidation, do you think the promoters or the directors of the company should be allowed to bid for the bid during the liquidation process? What is your opinion on that?
Yeah. No, absolutely not. I mean, Section 29, otherwise, you will be motivating people to drive the companies to liquidation if you lift the Section 29A embargo. So I think the answer is complete no. I mean, the 29A ineligibility should continue to be attached to the promoter. That is the fundamental principle that the defaulter cannot take back the company. Of course, if there is a policy change where some of the MSMEs are allowed, that's a different thing. But if they cannot buy in the resolution process, they should not be allowed to buy in the liquidation phase also.
There are concerns that during the COVID time, there would be the pool of people bidding for the assets of the company during liquidation would be very constrained. In that, it is expected that if the embargo is lifted, then a direct agreement between the creditors and the promoters could be reached. Otherwise, the process of liquidation may get elongated.
Oh, that's okay. That may be for some of the cases, but you cannot take out the principle. I mean, it has to apply. The sale of the asset is a subject matter of proper marketing. There is no asset which doesn't get picked up. Even the scrap gets sold. So I don't think that you will have any situation where the asset is not saleable at all. Of course, if there is no asset, if there are certain other things like actionable claims, and that's a very, very important area, especially in the EPC companies where you have actionable claims, and you cannot sell the actionable claims as such because Transfer of Property Act doesn't allow you to sell a right to sue. Other than that, all assets are saleable. And we just need to, we need to strengthen the processes. We need to strengthen the platform. Like IBBI said that they have created a platform where the RPs can put up the resolution processes or the bid offers, both in the resolution phase and also in the liquidation phase. We need to make that more robust, and more such platforms should be there. The investor connect should be there. The better marketing should happen. With all of that, I don't think we have any concern that the assets will not get sold.
Indeed. Coming back to Mr. Sharma, the question I wanted to ask was, we were discussing the liability of the directors,
Right.
and as 178 is being exempted, Section 178 of the Income Tax Act, there is an amendment introduced which stipulates that the IB code shall override that the IB code shall override the provisions of the code. The section which is pertinent right now is section 179, which deals with the vicarious liability of the directors.
Right.
That particular section is not amended.
Right.
Do you think that the tax authorities can take advantage of that section to hold the directors personally liable, even in
200%.
case the resolution plan?
Yes, so this is what going to happen, that in all circumstances the tax authorities, they are going to initiate proceedings against the directors, because obviously they are personally liable for the default of the company. During this procedure, obviously they can prove that there is no breach of trust or there is no negligence on their part. But obviously, since there is no amendment in 179, so the revenue department would surely use it.
Indeed. Mr. Rawat, the second question we wanted to ask you was that is in your experience the amendment which has introduced the provision of allowing liquidation through a going concern, do you think that provision has been effective? That the intention behind introducing that amendment is achieved?
See, if you look at the cases, these are very, very small cases, where the company comprised of, maybe small assets or maybe a very, very small business. I don't think you can use sale of the company as a going concern in liquidation for larger cases. There are massive, massive issues. One issue I said that, what do you do with the shareholding? The statutory provisions do not allow for that. What is the plan? There is no mention of a plan during the liquidation. What is the binding effect of a sale of a company as a going concern? When the company is sold as a going concern, then it is akin to a proposal that you receive in the resolution process period. What if the investor wants to offer a staggered payout, and that's the best way to maximize the value? There is no provision which says that the NCLT benches can approve a proper plan under the liquidation. Because of some judicial activism, it has happened. Some of the cases we have seen where NCLTs have allowed for the extinguishment of the existing shares, issuance of new shares, and have given some reliefs. But all of this, in the absence of a proper regulatory mechanism, it will be driven by the benches and they will keep on innovating. But I think from a long-term perspective, there has to be a proper process around it. The regulation must be very, very clear. The way it is in all the other jurisdictions, in developed jurisdiction, we have the benefit of looking at UK, US, and other developed jurisdiction, which have evolved the insolvency laws because of the practices that they did, because of the precedents that they have. I think we should use that. And there should be a constant training amongst all these stakeholders to understand how it should be brought into the legislation, either through the main amendment or through the regulation changes. But it has to happen. There has to be a guidance even to the benches. I mean, for how long the benches will keep on going beyond the written words and keep on innovating? There will definitely be some constraint here, and that does not give a clear consistency, because you have different benches then taking a different view. We have seen principal bench taking a different view. It is stayed by NCLT. So I think regulatory changes need to happen. Proper proper rules, processes around this particular method of sale needs to be put in the books, legislative books. And I'll defer to the member who's here. I mean, he'll have his own view on this particular aspect.
I'll reserve my comments on this issue.
Very well, member. Mr. Sharma, there is another to indirect taxation.
Yeah.
Now the GST Act, the issue that comes up in that act is, can the tax authority seek payment of the amount with interest by holding the directors liable in that to that extent? In that act also, there is no such amendment overriding the IB code, and this act had come into 2017. So whether GST gets to override the IB code?
See, my answer would be that as far as the pressing of demand and tax dues is concerned, one can understand that Section 238 is there. But as far as personal liability is concerned, wherein somebody needs to prove that whether there is gross negligence or not, so obviously the tax department would initiate action against the director and they would try to invoke the personal liability. However, in all circumstances, there are defense available to the directors as well. So finally, they have to prove that there was no breach of trust and they were not negligent in performing their duty.
That certainly makes a lot of relevance because a lot of issues have come up and they keep on coming up vis-a-vis tax tribunal judgments and the NCLAT. And I think with time only, if the Supreme Court does settle a lot of these issues, right now there are preliminary opinions on that, but then there are amendments to effect. The law as it is, it's a living organism, so let's hope we keep on evolving with it and improving upon it.
Right.
With that, I would like to thank Mr. Rawat, Mr. Sharma.
Thank you.
Honorable members, please take the floor. The session, the question answer session is over. I yield the floor to you.
Thank you. Yeah.
Thank you very much. Thank you, panelists. I think we have already exceeded Mr. Professor Risham Singh. Risham is, looking at us that, okay, floor is his now. I think we should close this session. And Mr. Risham, the floor is yours.
Thank you, sir. Thank you, and I'm sure this was a very interesting session on liquidation. And these sessions are running in continuation, and I see Mr. Behram Vakilji has already joined. The next session will be starting in another 2-3 minutes. So I thank all the eminent members for their valuable comments, and I'm sure our insolvency practitioners must have gained a lot. So as you can see, there are 175 participants in this meeting right now. That's a great encouragement for all of us. So I think with this, I thank you all, and we really appreciate all your support and your time for making this a successful event.
Thank you.
Thank you.
Thank you.
Thank you. Thanks.
Just close the browser. Not pressing the button. Hello, good afternoon. Good afternoon, Behramji. There are 3 buttons at the bottom. You just have to yeah. Okay, so I can see you and the others. Have they just joined in? Kanksha, Behram, Divyanshu. Okay, I think Dr. Sani has joined. Sophia has also joined. Great.
Good afternoon, Professor Risham Garg. Can you hear me?
Yes, sir. Certainly, sir.
Good afternoon to you and good afternoon to Behramji, and wish you all a very, very happy new year. And good morning to Sophia.
Good morning, everyone.
Yes, afternoon in India, morning in UK. Yes, so I think the floor is yours, Divyanshu.
Thank you so much. So have the participants joined, or they're all like it's just the panelists right now?
No, participants are there. There are 160 plus people who are logged in.
Okay.
So if you see on this button towards the left,
Right.
Dr. Sani, you can open your camera.
Okay.
So there is just one request to all the panelists. There are two buttons on the top right, pause and stop. Just don't fiddle with them because these will be very hazardous for us. So pause and stop towards the top right will, effectively end this session. So you just have to, control these three buttons on the bottom center. Towards the left is for the camera, and towards in the center is the audio. And the right red one will stop just the audio and video.
Right.
So thank you all. This was just a few housekeeping announcements that I had to make, and I just hope yes, Akanksha is here. So Akanksha, please start now. And I will request the coordinators, Tarun, Akanksha, Neelam, can you just copy whatever is in the chat box, because some insolvency practitioners have also mentioned their questions and their registration numbers. So it will be good if we can save them and keep in our records.
Yes, sir. I would hand over the session to Neelam to commence it.
Right.
So can we go ahead, Dr. Garg? Or there are some housekeeping announcements?
No. Everything is over. I mean, no housekeeping announcements. You can start. You're good to go.
Okay. Well, good afternoon to all the people who have logged in from India, and good morning to people who have logged in from overseas, I believe from UK. And welcome to all the panelists and a very happy new year. I am Divyanshu Pandey. I'm a partner at SNR Associates. I head the restructuring and banking practice at SNR Associates. I have got the privilege of moderating this esteemed panel today. So let me start with a quick introduction about the topic. The topic is implementing bankruptcy and integrating pre-PACs and other pre-insolvency regimes into a legal regime. To talk about this topic, we have a panel which is chaired by Dr. Navrang Saini. Dr. Navrang Saini is a whole-time member of IBBI, and he is currently heading the regulatory and monitoring wing of IBBI and is also in charge of the legal division of IBBI. We then have Mr. Behram Vakil, who's one of the founder partners of AZB and Partners, a prestigious law firm. Mr. Vakil has been actively involved in the legal profession for several number of years and has been part of Bankruptcy Law Reforms Committee and other committees which have been set up by Government of India to aid and implement the successful implementation of IBC. We have Dr. Sophia Elena, who is a lecturer at Nottingham Trent University in UK. Before that, she was a lecturer at Lancaster University. She is a specialist in corporate rescue programs in UK and Cyprus. In this session today, we will be talking about the various perspectives. So Dr. Saini will be giving us a regulator's perspective on implementation of bankruptcy for individuals and also on the pre-PACs. Mr. Vakil will be giving us the legal perspective of the pre-PAC regime, which can be implemented in India or the ideal design of such a pre-PAC regime. Dr. Sophia will be talking to us about general corporate rescue program regimes in UK and USA, and also in terms of what is the mechanism used for pre-PACs in those jurisdictions. I will be talking about whether scheme of arrangement under Companies Act can be an option for debt restructuring or for pre-PACs in the Indian framework or not. So on that note, I would like to hand over to Dr. Saini to kind of start the session. Dr. Sunny, over to you, please.
Thank you very much, Divyanshu Pandeji, for the brief introduction and moderating the session. And thank you, Professor Isham Garg, for inviting us in this virtual international symposium on IBC 2016. And thank you, Behramji, and of course, Professor Sophia Elena, for joining this session. Well, to begin with, the prime objective. Oh, there's something. Sorry, there was some technical hitch. The prime objective of IBC is to rescue corporate debtors in distress. The code specifies a time-bound insolvency resolution process which needs to be completed within 330 days, including any litigation. The fulfillment of Insolvency and Bankruptcy Court's objectives is evident from the cases that have seen successful resolutions. As per data available up to 31st December 2020, 308 resolution plans has been approved. The number of companies that are under liquidation process is 1,112, which is about 47.99% of CIRPs which were closed, ended in liquidation, as compared to 13.29% ending with a resolution plan. In 308 CIRP, the realization by all creditors in comparison to liquidation value in respect of the corporate debtors is 193.19%, and realization by them in comparison to their admitted claims is 39.91%. IBC has been one of the enablers in improving India's ease of doing business, ranking from 130 in 2016 to 63 in 2020. The IBBI has provided a clear and transparent roadmap for investors to wind up their businesses. The code, that is the IBC, reconceptualized the framework for insolvency resolution in India. It envisages a time-bound market mechanism to rescue firms in financial distress and to facilitate closure of firms in economic distress in accordance with the provisions under the code and rules and regulations made thereunder. We all know that a distressed asset has a life cycle. Its value declines with time if distress is not addressed in a timely manner. Thus, there is a merit in addressing the distress as early as possible. In recognition of this, the Insolvency and Bankruptcy Court entitles the stakeholders to initiate CIRP at the earliest default of a threshold amount. However, they may have number of reasons not to initiate CIRP. Even after initiating a CIRP, they make midway. Thus, the court addresses distress only after a default has occurred and the stakeholders wish to address the distress through CIRP. The court addresses the distress usually through a resolution plan, failing which the corporate debtor is liquidated. In the Indian restructuring ecosystem, there are two kinds of resolution, one under the code and the other outside the code. Both have pros and cons. A resolution plan under the code is a time-bound, market-driven and transparent process so as to achieve the best possible resolution with maximization of the value of assets of the corporate debtor. In view of its process sanctity, the resolution plan enjoys certain benefits under various other laws. However, the process is not bereft of drawbacks such as costs involved, and conclusion of a process often takes longer than the timelines envisaged in the code. The code does not envisage addressing of distress prior to default. A formal or informal resolution process outside the code provides flexibility, cost efficiency, and speed. The outcome of such process, however, does not enjoy the benefit associated with a resolution plan approved under the code. More importantly, if it does not go through a competitive, it may not with the valuation. IBC is an economic law. It involves continuously through experimentation. To stay experimentation in things economic is a grave responsibility, and denial of the right to experiment is fraught with serious consequences to the nation. The code is no exception. It has been a road under construction. The very first resolution plan in the Synergy Dure approved under the code yielded a haircut of 94% for financial creditors, while promoters wrested control of the company. This was considered rewarding unscrupulous persons at the expense of creditors. The code made prompt course corrections through an ordinance that prohibited persons with specified ineligibilities from submitting resolution plan in a corporate insolvency resolution process to ensure sustained resolution of stress. Probably as a precursor to pre-pack, the next amendment to the code enabled closure of a CIRP with approval of 90% of voting share of Committee of Creditors. The code has so far witnessed 5 legislative interventions, 4 of which are by way of ordinances in view of urgencies, which demonstrate the keenness of the government to continuously improve resolution framework. Each of these 5 amendments has strengthened the processes in sync with the emerging market realities and reinforced the primary objective of the code, that is revival of companies. Since the enactment of the code, several companies, including exceptionally large ones, changed hands consequently. The credible threat of IBC process redefined the debtor-creditor relationship. The defaulter's paradise was lost. Many debtors today prefer to resolve stress at early stages and are making best efforts to avoid consequences of CIRPs. They are resolving stress when it is imminent on receipt of a notice for repayment, but before filing an application to initiate CIRP, after filing application, but before its admission, and even after admission of the application. The evidence is withdrawal of applications filed for initiation of CIRP in respect of approximately 15,000 corporate debtors, and withdrawal of many applications under section 12A of the code, termination of CIRP by the adjudicating authorities, closure of CIRPs on taking note of settlement recorded by the mediator, and even settlements at the level of apex court where the parties worked out a resolution amicably, resulting in swift revival of the corporate debtors. A fair debtor-creditor relationship induced by the code has prompted several resolutions in its shadow or in its count. Both empirical and anecdotal evidence suggests that the code has rebalanced the relationship between debtors and creditors to a large extent and is leading to more responsible decision making by both debtors and creditors, which is encouraging a large number of out-of-court settlements. With considerable learning and maturity of the ecosystem and a reasonably fair debtor-creditor relationship in place, the ground seems ready to experiment new options for resolution of stresses under the code in furtherance of its objectives. The experience from implementation of the code, including evolution of the ecosystem, stabilization of process, growing jurisprudence has prepared ground to look at new initiatives to further improve the effectiveness of the code. The then Minister for Finance and Corporate Affairs, late Sri Arun Jaitley, advocated that going forward, once an honest creditor-debtor relationship was restored on account of the code, there would be a need to marry the insolvency framework with out-of-court settlements schemes. In the wake of COVID-19, there is a fear that many CDs may fail to repay loans, which may push them into insolvency proceedings. Reportedly, many such companies were doing well before the onset of COVID-19 and are not doing well mainly or only on account of COVID-19. It is being advocated by a section of stakeholders that a separate dispensation may be provided to resolve the stress of the companies. This dispensation should both enable and incentivize the promoters and the creditors to work out a formal settlement backed by the code. Given the pros and cons with each of the two approaches for resolution, there is an increasing demand for a hybrid approach to address the distress. A hybrid approach blends the benefits of resolution outside the court, such as flexibility, cost effectiveness, and time effectiveness, and the legal sanctity, finality, and statutory and regulatory dispensations for resolution plans under the code. In a sense, the resolutions under the code and resolutions outside the code are two ends of spectrum, and a variety of hybrid structures that combine elements from both types of resolutions have come up between the two ends to meet the convenience of stakeholders. Most hybrid structures are confidential up to a stage and transparent thereafter, and require some amount of judicial determination and engagement of stakeholders. Pre-pack is one of the more common hybrid structure that many jurisdictions have adopted. Usually under the pre-pack, the terms of restructuring are confidentially negotiated between the corporate debtor and its creditors, and then the plan is submitted to the judicial authority under a formal insolvency process for approval to avail of the benefits such as claim down, etc. The nonsense of pre-pack differs from one jurisdiction to another. Sometimes even within a jurisdiction, there may exist more than one variant of pre-pack. Pre-pack gives the stakeholder a flexibility in working out a consensus strategy for effective resolution and value maximization in a time and cost-effective manner that may not be possible under the formal insolvency law. The debtors and creditors prefer pre-pack for its features such as claim down, binding nature, etc., or any other kind of restructuring process, whether formal or informal. Various versions of pre-pack approach exist in many jurisdictions, and almost each jurisdiction with a developed insolvency regime has its own version of a pre-pack procedure. The examples are pre-pack administration in the UK, pre-packaged and pre-arranged bankruptcy under Chapter 11 of the US law, scheme of arrangement under the Companies Act 2003, Companies Act in Singapore, etc. Of course, scheme of restructure, arrangement, etc. exists under the Companies Act in India also. In India, the government of India is considering a pre-packaged insolvency resolution process. The Ministry of Corporate Affairs, via its order dated 24th of June 2020, constituted a subcommittee of Insolvency Law Committee. The subcommittee has submitted its report, and the same is under active consideration of the government. For the benefit of the participants of this symposium, I would like to inform the important recommendations of the subcommittee. The most important recommendation of the subcommittee is that it is opportune time to provide a framework for pre-pack for resolution of insolvency under the code as an additional option for resolution, which blends features of both formal and informal options. It should start with the simplest variant, which may acquire advanced features in course of time. It should yield a resolution plan as envisaged under the code. The other recommendations are: the framework must be within the basic structure of the code. It should have the rigor and discipline of IBC and pursue the same objectives as the code does. It should not impair rights of any party beyond what is provided in the code, and should have adequate checks and balances to prevent any abuse. It should enjoy the same regulatory benefits as are available to CIRP. The code may be amended quickly, preferably by an ordinance, to provide for formal part of pre-pack. The code may make a skeleton provision enabling pre-pack, while informal part could be left to market practice or guided by self-regulation guidelines, best practices, etc. Pre-pack should be available for all corporate debtors and for any stress pre-default and post-default, depending on policy objective, capacity of the National Company Law Tribunal, and availability of SIRP for MSMEs. The implementation could be phased. It may commence in respect of defaults from rupees 1 lakh to rupees 1 crore and COVID-19 defaults for which CIRP is not available today, followed by default above rupees 1 crore and then default from rupees 1 to rupees 1 lakh. Pre-pack in respect of pre-default may be considered with consent of higher threshold, say 75% of all creditors after successful implementation of post-default resolutions. The corporate debtor shall initiate pre-pack with consent of simple majority of A. Unrelated financial creditors, B. Its shareholders. No two pre-proceedings, pre-pack and CIRP shall run in parallel. There shall be a cooling off that a pre-pack cannot be initiated within 3 years of closure of another pre-pack. The corporate debtor shall remain under the control and possession of the current promoters and management during pre-pack process. This is different from the CIRP, because in the CIRP the management is taken over by the IP. But here, the promoters will continue in the management. Decisions or matters enumerated under Section 28 of the Code, including interim finance, shall be taken by the corporate debtor with the approval of the Committee of Creditors. The corporate debtor shall make available an updated list of outstanding claims, including contingent and future claims, and a draft information memorandum based on its books, duly certified by its chairman or managing director or managing partner, along with an indemnification that if any claim is omitted, they will be personally liable to make such claim good. Further, if the corporate debtor willfully provides any wrong information or omits to provide material information with respect to any claim, the same shall attract criminal liability. The moratorium under Section 14 of the Code shall be available from the pre-pack commencement date till closure or termination of process, whether by approval of resolution plan or otherwise. It shall not, however, cover essential and critical services. An insolvency professional shall play the role of RP in pre-packs. He shall conduct the process and not run the operations of the CD. He shall ensure transparency and fairness of the process, safeguard the interest of stakeholders, business, and the public, and ensure compliances with the law as regards the process. The choice of IP and his terms of appointment shall have consent of majority of unrelated financial creditors. The RP shall publish the public announcement on an electronic platform which shall be disseminated to the creditors by an information utility. He shall verify claims and finalize IF. The RP shall constitute the committee of creditors comprising unrelated financial creditors, that is unrelated to operational creditors where the CD does not have any unrelated financial creditors within 7 days of the ECT. The RP shall get valuation, liquidation value, and fair value of the CD done by valuers. The RP shall conduct the usual due diligence and make applications to the AA in respect of avoidance transactions. In pre-packs, the COC shall take decisions with the approval of required majority of votes present and voting. Only the decision to liquidate the corporate debtor would require approval by 75% of voting share. The committee of creditors may decide to close the process with approval of 66% of voting share present and voting if the corporate debtor engages in any activity which has potential to cause depletion of assets or value to the detriment of creditors. It may even decide with 75% of the voting share to liquidate the corporate debtor at any time during the pre-pack process. There shall be no dilution of provisions of Section 29A in respect of resolution applicant for submission of resolution. This is very important, as they are actually not diluting. It is not proposed to dilute the provisions of Section 29A. The pre-pack should start with a base resolution plan which will face Swiss challenge. This is again an important provision. This should come from the promoters if they are eligible and interested. Otherwise, the committee of creditors may arrange a base plan. The pre-pack should offer two optional approaches, namely without Swiss challenge but no impairment to OCs, and with Swiss challenge with rights of OCs and dissenting FCs subject to minimum provided under Section 30, subsection 2, clause B. It shall not be necessary that the resolution value shall be higher than the realizable value. There shall be no requirement of validation of the resolution value by an experienced person. The design of the Swiss challenge needs to balance the incentives and disincentives of the promoters and the Swiss challenger to drive value maximization. So, object in the pre-pack is also to drive value maximization. The pre-pack shall not end up with liquidation except when the committee of creditors decides to liquidate the CD with 75% voting share. There will, however, be no liquidation where pre-pack was initiated for pre-default stage, default below the threshold for ARP and COVID-19 default. The insolvency resolution process costs shall include interim finance, fee of RP, and other process-related costs incurred by committee members, but will not include cost incurred to run the process. In the normal CARP, the cost to run the process is also included, but here it is proposed not to include that. The pre-pack should allow.
Sorry, Dr. Saini.
Sir, may I?
Sorry.
Am I exceeding the time?
Sir,
Yes,
there are a lot of questions. I mean, our insolvency practitioners are also asking lots of questions. So you are thinking.
Okay, I'll just conclude that. So these are actually the basic recommendations of the committee. I just thought that it may be useful for the actually the participants who have not gone through the committee report. But just to before to hand over to my colleague, I would like to say that let's hope for early implementation of the pre-pack system in India. Thank you very much.
Thank you, Dr. Saidi, for such an insightful overview of the recommendations made by the subcommittee to the ministry. Mr. Vakil, I'm not so sure, or rather I would say I'm ignorant whether you are part of that panel or not, but given the broad features which Mr. Saini has set out with respect to the pre-pack regime which is being envisaged to be implemented in India, your thoughts would be very much welcome on that. Am I audible, Mr. Vakil? Mr. Vakil, am I audible to you? I think we can come back to Mr. Vakil later. So if there could be some technical issues which could be there. So if I could request, after hearing what could be in the offing the P-PAC regime in India, if Dr. Alina could kind of give us an overview of the corporate rescue in UK and USA and what kind of P-PAC regime exists over there.
Yeah, can I share my screen for a PowerPoint presentation?
Sure.
Yeah, just a second. Can you see it?
Not yet, but it's saying screen is loading.
I see. It tells me that it's shared, so I don't know if some people can see it already. If there's a problem, I will continue without the slides. That's not a problem.
No, it's there. We can see it now.
Okay. So, yeah. This is a comparison between, I would like to thank everyone for inviting me today to speak, first of all. And this is basically a comparison between Chapter 11 in the US and the administration in the UK. I will give you some context on pre-PAC 2 as it was mentioned. And this is about the rescue attitudes of both jurisdictions. When we're talking about administration, it's usually seen as a creditor-oriented procedure, while Chapter 11 is viewed as a debtor-oriented procedure. And I chose those two jurisdictions because many other jurisdictions choose the features from both administration and Chapter 11 to imitate some of them. So I thought that could be a useful comparison and everything. One of my arguments in this presentation is that history has shown that creditors will manipulate the law on their own end. Thus, it's important to look at the law as it is shaped by its stakeholders in general. I am arguing that I am arguing that labels are important when we are talking about the orientation of the system and what it aims to achieve and how it operates, and that could have economic consequences. So I aim to identify whether it's indeed a creditor or a debtor-driven procedure. And I have some quantitative data that I collected myself. That data focuses on the UK administration, though I use some data from other colleagues in the US to illustrate some of the Chapter 11 outcomes in terms of rescue. I thought that it was important to compare the corporate company rescue with business rescue. There's both rescue culture in both administration and Chapter 11. But the level of expectation is distinct. It seems that in the UK, they are more towards business rescue, while in Chapter 11, they are more towards company rescue. When we are talking about company rescue, is the rehabilitation of the business and the company, which means that you get to keep the name of the company. While when we are talking about business rescue, it's the sale of the viable part of the company to a new business, a new company. And I am also using the Schutter's creative destruction theory, which says that basically weaker companies can be substituted with rival companies that are stronger and manage to flourish because weaker companies do not remain competitive, which could lead them to collapsing. And I am also asking whether rescue should be given as a right or not. And in the UK, it seems that rescue should be selective, while in the US, it's advocated that it should be available for all companies. I am also arguing that company rescue might be too ideal and that business rescue should be not viewed as negatively. And it's important to mention that it could be a business rescue could be achieved through prepackaged administration or through prepackaged Chapter 11, and business rescue could include employees, receivables, assets, stock in trade, the working process, the executory contracts, and suppliers. So it should not be viewed that negatively, since all of those aspects of the business will be saved. Now, in terms of administration, let me go to the next slide. Yeah, there was an evolution of the procedure in 2002 through the Enterprise Act, in which that included the abolition of administrative receivership, which was clearly a creditor-oriented procedure, and there's path dependency on administrative receiverships since it's still alive through administration. I will get back to that. And out of court appointments of administrators were introduced, which means that the court intervention is not necessary anymore. The three hierarchical objectives were also introduced, which includes the first objective, which is the company rescue, then business rescue, and then the realization of assets, which is the third one. A moratorium that could protect the company against credit was initiated, and through the Corporate Insolvency and Governance Act in 2020, which was initiated after the pandemic, the freestanding moratorium was introduced, which is not a money share displacement procedure as is in administration. And time will show whether that particular procedure will succeed and whether it can help distressed companies. Now, in terms of prepackaged administration, it's a quick business sale, which is basically akin to what administrative receivership could do before the Enterprise Act of 2002. And this particular procedure, the prepackaged administration, has been largely criticized by the government, media, commentators, the judiciary, and creditors because of the sales to connected parties. That is sold back to the people who had the company before. The Graham report was introduced in 2014, which had some recommendations on how to improve that procedure and how to limit the criticism against pre-pack. And it seems that this was not that successful because many of the recommendations have failed, which led to other changes which happened after COVID-19. Several measures were put in place with this situation, and this includes the pre-pack draft regulation. There is the anticipation that during these extraordinary times, the pre-pack will be really useful to companies for businesses to survive, which also means that employment will be preserved.
May I request people who are not speaking to go on mute, please?
Pardon?
No, sorry. Yeah. There was a bit of background noise, Sophia, so I will ask people to go on mute.
Yeah, shall I continue? Yeah?
Yes, please. Yes,
yeah,
please.
Okay. Yeah, I was on pre-packs and about the draft regulation that will be introduced in June of 2021. I'm not sure whether this will work out because one of the main features that have been used in the UK regarding pre-packs is the speediness of it and the fact that a draft regulation involves the court, has a court involvement. I'm not sure whether that will limit the speediness and whether that will basically change how the procedure functions at the moment. I believe that it will limit the criticism and everything, but I'm not sure whether it will have the same results are today that facilitates the business rescue through hiding down. I am also arguing that financing is really important, which we will see in Chapter 11 that procedure facilitates that. And now, Chapter 11 is a debtor in possession procedure, which is different from administration. And this encourages early intervention, and the managers in the US are basically considered as more suitable to deal with the procedure, whereas in the UK that has been largely criticized that managers, especially of smaller companies, are not able to deal with insolvency processes. This refrains from insolvency practitioners' fees. And however, this procedure was one that was once used by managers as an anti-takeover mechanism, no longer has that use. A stay is also in force, which is also extended to executory contracts with suppliers and customers. This feature has been now introduced in the UK through the 2020 Act. And it's a court-driven procedure, And this basically has criticisms about the accountability and decisions of the judges of lawyers, especially if we are talking about it from the perspective of the English practitioners and academics, and that could increase the costs of the procedure. And creditors found a way to exert control over the company when we're talking about Chapter 11 through debtor imposition of financing agreements and the cram down feature of the procedure. And I also have some data from my data collection. As I mentioned before, the database includes 600 companies, and I collected data such as the companies that show how many companies chose objective A, B, and C, and the outcomes of those objectives. As you can see in the first chart, only 17 companies out of 600 chose to pursue objective A, which is company rescue, which shows us that companies in the UK do not usually follow that path. If we see the second objective, it facilitates business rescue, so 205 companies followed that, while most companies that entered administration went for an asset realization. The result of those objectives was that only 3 out of 600 companies managed to save the company or part of it. Around 1/3 managed to save the business or part of the business, and almost 400 companies out of the 600 companies realized their assets. So most companies were not really saved through administration. However, I will show you how that's viewed in the UK. This business rescue has been endorsed by the core committee, which was a committee that initiated the main insolvency act in the UK. Various aspects of the law implicate the idea of creditor-oriented, debtor-oriented regime, and paragraph 3.2 of the act is one of them. And in other words, it says that there's no requirement to follow rescue if the result for creditors will be negative. So the Act tells us that if the result is negative for creditors, rescue is not that important in those circumstances. There is a high failure of paragraph 74, which are the challenges that can be launched by debtors, which also implicates that idea. We can see that objective B and C are basically similar to administrative receivership that was in force before 2002, which shows us that they are that creditors are still in control. And some scholars even described administration like a disguised administrative receivership. I also have some results for the creditors of the company. The credit from my database, as I mentioned before, only 38% of the secured creditors managed to receive £100 in 100 pence in a pound, and only 55.9% of preferential creditors got 50%, 100% in a pound, and which shows that unsecured creditors are the most vulnerable stakeholders in company rescues, since only 1.33% receive full returns. And
may I interrupt over here, just to kind of like sound out on the time, just keeping a tab.
Yeah, I will wrap it up. There's just one slide left. Yeah. Just give me a few seconds and I will be done.
Sorry about this, but just being very cautious about the time.
I'll just show you the development of the USA. We can see that even though there is a path towards company rescue, the business rescue is also followed. We can see from the results that company rescue is more possible to happen through Chapter 11, since we can see that 33%. 0.7% of the companies managed to save the company, while in the UK only 3 companies out of 600 managed to do that, which makes us question whether Chapter 11 could be better procedure to follow. Again, pre-packs are also followed in Chapter 11 when business rescue is followed, and and that's also followed. Some final thoughts, and I'm done. Thank you very much.
Many thanks, Sophia, for that helpful comparison between the UK and the USA rescue regime, and especially with some elements of how the pre-pack works over there. It will be very helpful to now also get Behram's perspective. Mr. Vakil, can you hear me? Mr. Vakil, are you on the call? Let's bear with the technical problems he might be facing. So, just continuing with that discussion, that it's good to know that the two regimes, the one in UK is more based on business rescue, while in US it is more company rescue. And what I could follow from what Dr. Seni was giving us an overview of the key recommendations made by the panel, it appears that we have taken more or from Chapter 11, at least that's the recommendation which kind of is on the table for the ministry to consider, where there should be a resolution. Though noticeable changes definitely are there because the management continues. So I think that itself is a kind of a different regime as compared to CIRP, which would enable that the discussions can be structured, negotiated, and can be implemented through the court mechanism. And then overall having an RP to supervise the process will ensure that at least there is streamlining of information between the various stakeholders, and that there is preservation of assets as well, and to ensure that all stakeholders' interests are balanced. So definitely, while the fine print is yet to be out, and we all will be very keen to see the fine print, but let's see when the panel kind of gets its reports approved and it is tabled for public consumption. I'm not sure if Mr. Vakil is still having the technical problem or not. Dr. Tarun, Dr. Garg, are you in touch with Mr. Vakil so that we can kind of get him on the call and hear his perspectives as well?
I cannot actually. As far as I see, I think he is. He should be.
I cannot see him on my screen, but on the participants he is there. Mr. Vakil? Mr. Vakil, can you hear us?
Yeah. Now we can see him.
Mr. Vakil, am I audible? Dr. Garg, do you want to say something? I don't know whether it's my connection or I'm not audible to him, or.
No, I think you are perfectly audible, and as I see the Mr. Vakil, I hope you can hear us. Controls look fine. Yeah.
Do you want to call him up, or should we call him up?
Yeah, you can. If you think you can call him up.
Yeah, if you could just bear with me for a second. My apologies for this. for this technical glitch which has happened. Just bear with me for a second.
Okay, so let us see if we have a few questions here.
Hi, Graham. This is Divyanshu. Can you hit
Under prepackaged, how transparency shall be ensured in the bidding process?
I can't hear you at all. We could see you, but we couldn't hear you. At times, you're
Right. So if you can take one question, maybe Dr. Sani and both Sophia can have their views on this. It's a very common question under prepackaged resolution. How transparency can be ensured in the bidding process so as to enable fast decision by bankers?
Professor Gar, in India, actually a hybrid approach is proposed, wherein, of course, the promoters will be in control, but actually the insolvency professional will be overseeing the process. So definitely, he will be actually, I think, looking after the transparency issue also simultaneously. And of course, the committee of creditors is there, so they will also be having a control over them. Over to Sophia.
I am muted now. Yeah. So if we look at it from the perspective of the UK, this has been highly criticized that pre-packs are not transparent, and that creditors not all creditors are really involved. But on the other hand, pre-packs cannot really succeed if the main creditors are not involved. So we need the involvement of those creditors. There were various recommendations from the Graham report that I mentioned before, and they were incorporated, like the pre-pack pool and the viability review, which were basically incorporated to deal with the criticisms against the sales to connected parties. But it seems that because those procedures are not mandatory, they are not really used. That's why the draft regulations were proposed that will basically be enforced by June of 2021 to deal with the transparency issues and the criticisms. That's from the UK perspective, at least.
No, that's very helpful, Sophia. Thank you. And just managed to connect with Mr. Vakil. He sends his apologies. He's having technical problems and hence cannot connect because he's not audible on the call. So he sends his apologies to all the participants. I think, Dr. Garg, we are nearing the session. So do you want me to talk about the scheme, or should we open the floor for question and answers, and all three of us, Dr. Saini, Sophia, and I, can pitch in wherever we can provide our inputs and thoughts?
I think that, there are not many questions in the chat box, but it will be very helpful if you can make your presentation on the schemes of arrangement, and that would be very helpful.
So I'll try and keep it brief, because most of the features which would have got covered is perhaps already getting covered, a large part of it under the recommendations which have been made to the committee. I'm just trying to open the content.
Have you saved it somewhere?
Yeah.
Okay. Right. Okay. Yeah, that's there.
Okay, great. So just a quick overview. Scheme of arrangement is a feature of English law. As a matter of legacy, it has been in our Indian Companies Act, because our Companies Act was pretty much modeled on UK Companies Act. Since 1913, it has been there. In the current form of Companies Act, which is 2013 Company Act, it is under section 230. As Dr. Saini also mentioned, that pre-pack regime is being structured as a hybrid mechanism whereby negotiated contractual arrangements for debt structuring are implemented through intervention of courts. So scheme of arrangement can also be used as a tool for debt structuring as a hybrid mechanism. It's been extensively been used in UK and Singapore. However, in India, it has been used usually for corporate restructurings, and that too more in the nature of merger, demerger, or amalgamation of the companies. But we must keep in mind that it can also be used for solvent and insolvent companies. The reason for the scant use of scheme of arrangement for debt restructuring, even though the provisions have been there for such a long time, in my understanding, are mainly twofold. One, because most of the lenders in the Indian credit market have been primarily banks. So the regulatory forbearance which was available to them under out-of-court restructuring mechanism under the various RBI framework is not available to them if they go under the scheme. And hence it was not popularly used by the creditors as well. Two, the fact that it is under general law, which is the Companies Act, any creditor protection laws, the special laws like SICA or RDDB or SARFACI, which were for enforcement of security interests and recovery of money, or for rehabilitation under SICA, they always trumped up the General Companies Act because it was earlier in time and it was also a general law. So these were the main reasons why we have not seen very many debt restructurings being implemented. There are few examples of Arvind Paper Mills, BPL, SR Oil, which have happened, but there is no comprehensive database in terms of how many debt restructurings have been carried out through a scheme of arrangement. Just very quickly, the key features are, it's a debtor in possession model, as we all know. It can be initiated by an application by a creditor, a corporate debtor, or a liquidator. The good thing is the fact that this is a collective process. So it is not a selective negotiated deal. It is more where all the stakeholders get involved. The voting rights are vested in all class of creditors and also the shareholders. It requires approval of each class of creditors, and in each class, at least 75% by value of the creditors have to approve it. The basis for determination of class is similarity of rights and common interest. So it's not that like the debenture holders will constitute a separate class or foreign lenders will constitute a separate class, depending upon whether they are secured or unsecured. They can be treated to be as class of one financial creditors. Then it has the same effect that it is binding on all stakeholders. So it is different to that extent from an out-of-court negotiated debt restructuring, where it is applicable only to the people who have signed up to it. Any objection to a scheme can be raised by a creditor who has got more than 5% of the debt, or by a shareholder if he has more than 10% or more of the shareholding. A very quick comparison between CIRP and scheme of arrangement. Time-bound process, scheme of arrangement is not, but CIRP is. The automatic moratorium is not applicable under scheme of arrangement, and this is something which has been mentioned by Dr. Saini as well, that would be available for pre-packs, and in CIRP it is there. The model, the scheme of arrangement is a debtor in possession model. CIRP is a creditor in possession model. Approval thresholds for passage of scheme or passage of a plan. So there's one distinction over here, that because each class has to vote, if a particular class does not vote, then it can stall the entire scheme process. Or if a particular class does not have the requisite threshold, then it can stall the entire scheme process. Unlike IBC, whereby it's only the financial creditors who are voting, and by virtue of 66% of vote, if they have approved it, then all other creditors as well as all other stakeholders get bound by it. 29A is not applicable to scheme of arrangement for debt restructuring, but it applies if it is adopted during liquidation, where the sale of assets is explored under Section 230. Under CIRP, it is applicable. The management of company continues with the existing management under the scheme of arrangement, and in CIRP, as we all know, it is vested in the resolution professional. Some of the changes which can make scheme a good mechanism for it being adopted as a tool for debt restructuring and also for pre-pack, I have listed down some, that there should be an automatic, and this will require certain legislative changes, certain regulatory changes also across different laws. So the moratorium applicability should be there as it was earlier in Companies Act 1956. I think in 2013 Act, it perhaps inadvertently got missed. Just to, for your information, under 1956 Act, one could petition the court to grant a moratorium. So either it can be on those lines, or it should be, or it could be an automatic moratorium for a certain time period, so that it cannot be misused or abused. Or if there is any instances of abuse found, then there should be grounds for revoking it. The voting threshold should also be reduced from 75% to 66% to align it with the IBC. The fact that a particular class can stall the process, I think the provisions should be amended to say that if by number and by value the entire majority of creditors and stakeholders have approved it, then if a particular class has not approved it, then that should not stall the process. I think we need to keep in mind the Indian realities as well. So some regulatory forbearance in terms of NPA classification and all should be given to those debt restructuring plans which are being implemented under June 7th framework and where scheme is being deployed for making those resolution plan binding on all stakeholders. Other aspects could be just to ensure that there is no asset stripping, and as Dr. Seni mentioned with respect to the pre-pack regime, we can also think of having combining features of what Sophia also mentioned, that pre-pack administration, where the entire scheme is overlooked or is under the supervision of a resolution professional, but he is just ensuring compliance with the process and is not running the company per se. In addition to that, there are certain aspects which can be considered is that there should be priority to additional funding, which Sophia also mentioned, the concept of DIP financing under US laws. 29A relaxation is a key, according to me. That's my personal view, because if we really want pre-pack and schemes to be working, and we want that the existing management should have a chance to rescue the asset or the business, then we need to make this exemption at least till such time the scheme is going on. And of course, defining a time-bound process under which the scheme has to be implemented. Then the fact that, as I had mentioned earlier, the company law being a general law was trumped over by special laws like SARFAESI and all, so that should be kind of avoided by extending the moratorium, which I've already covered. And the same regulatory benefits which are applicable under IBC, the concessions under takeover code, various laws should also extend to a scheme which has been sanctioned by the court. And if there is a new resolution applicant coming in and not the existing management, then the new resolution applicant should get a clean slate. Above all, this is just a recommendation. So if these features could be considered or maybe suitably be tweaked in the pre-pack regime, then it would be kind of like, we will see that, as I mentioned, the fine print, and if it could effectively bolster where scheme of arrangements do get used more often in debt restructuring, as we see in other jurisdictions like UK and Singapore. Thank you very much.
So thank you, Divyanshu, and thank you all the speakers. So I think the next session is going to start at 4:30, and may I just request the chair, Dr. Navrang Saini, to give his concluding remarks in the next 2 minutes, please.
Thank you, Professor Rishamji. We all know that journey of IBC till now has been revolutionary, In wake of COVID-19 pandemic related fear of enhanced volume of insolvencies, pre-packaged insolvency framework is being actively considered in India with adequate checks and balances. As discussed, it would be a hybrid structure maintaining speed and efficiency while ensuring transparency and accountability. All versions of pre-packed framework in different jurisdictions are being considered while arriving at a framework suitable for Indian requirements. I thank my co-panelists for sharing their insightful perspectives on pre-pack. Madam Sophia discussed in detail the UK's and USA's experience with rescue regimes, particularly the pre-pack framework. Mr. Diptanshu moderated the session well, very well, I can say, and discussed various dimensions of the pre-pack framework and scheme of arrangements in this context and amendments required in debt restructuring scheme. Mr. Behram Vakil could not join due to technical fault. So at the close, I would like to reiterate that proposed Indian pre-pack framework, though simplified, will be in line with the basic structure of the code and ensure due adherence to transparency and accountability standards. It will strive to further the objectives of the code and help us tide over this COVID-related impact on insolvency landscape. Thank you very much to my co-panelists and all the participants. Thank you very much.
Thank you, Dr. Saini, for those concluding remarks.
Thank you, all the eminent panelists, and hope to see you soon again.
Yeah. Thank you, Dr. Gar, for this opportunity. Thank you, Sophia.
Thank you, everyone.
Right. So we'll just quickly. Again, you may continue to be in the session. Just switch. You can switch off your videos, and I think we are going to start the next session immediately. Dr. Saini, you can just
I'll seek your permission to leave the session. Thank you very much, Professor Gar.
Thank you, sir. Thank you for your consideration, sir, and your valuable time. We really appreciate your great support to this event.
Thank you, Professor. Thank you.
Thank you. Right. So the next panel speakers are already here. I can see Professor Irit is there. Kate Lannon is also here. Right. Hello, Kate. Good to see you. Welcome to NLU Delhi, India.
Thank you very much. Nice to see you as well.
Yeah. Hello, Professor Irit. Welcome.
Good morning, good afternoon, everyone.
Dr. Jayaram has joined.
Hello, everyone. Very good evening.
Good evening, good afternoon. Okay. Right. So Dr. Jairam is also here. I think we are just at the time of the session is starting, so I'll just make a couple of housekeeping arrangements. If you can see on the top right two buttons, that is pause and stop. I mean, it's just better to avoid them. There is no need to touch those two buttons. We have three buttons in the center. The red one is for switching off the mic and the camera. Center one is for the mic. Left one is for the camera. That's just the controls that we need to take care of. Right. So now I think I should invite the coordinator to start the proceedings. Oshika.
Hello. Okay, I'll begin the session then. Sir, I believe Mr. Somashekar Sudarshan hasn't joined us yet.
Okay, so in anyway, I think you should start because we are on time and we should ask our ancestral guests to continue. I'll just try to contact Som, so you can start now.
Okay, sir, I'll just start. Very good afternoon to everyone. Welcome to the fourth session of the conference on cross-border insolvency. Today we have a very esteemed and special panel of experts who are going to discuss various aspects of cross-border insolvency with us. So there will be a very extensive discussion on the role of UNCITRAL, the model law on cross-border insolvency, the model law on recognition and enforcement of insolvency-related judgments, and we will also get an insight into the workings of IBBI and the Ministry of Corporate Affairs in relation to cross-border regime for India. So, before starting the session, I would like to briefly introduce our panelists for all the participants. So, first on the panel we have Kathleen Anand, a senior legal officer from UNCITRAL. Kathleen Lennon is a senior legal officer at UNCITRAL based in Vienna. Prior to joining the UN, she was in private practice and served as a member of Canadian Diplomatic Corps. She has also worked in area of private international law and was also called to bars of Ontario, Canada, the state of New York, and Washington DC. Next, we have Richard Leonard. Professor Richard Leonard is the Dean of Norman Adrian Wiggins School of Law at Campbell University. He has also served as the U.S. bankruptcy judge for the Eastern District of North Carolina and was also chief judge until 2005. He was also awarded the prestigious American Bar Associate, prestigious Robert Legge Award in 2011. And for more than a decade, he has also acted as a consultant to the U.S. Department of State. Next on the panel, we have Dr. Kokila Jairam, DGM, IBBI. Dr. Kokila Jairam is an Indian Economic Service Officer who serves as the Deputy General Manager at the Insolvency and Bankruptcy Board of India, and she oversees the corporate insolvency resolution process amongst other functions. Next, we have Mr. Somashekar Sudarshan, advocate and member of Insolvency Law Committee on Cross-Border Insolvency. Mr. Sudarshan is an independent counsel and his work mainly focuses on Indian regulatory litigation, which covers security law, competition law, company law, and so on. Currently, he is also a member of Ministry of Corporate Affairs Insolvency Law Committee, which is working on cross-border insolvency. He was also a partner in JSA and was the head of financial sector. Next, we have Professor Eric Mevorak from Nottingham University. Professor Eric is a professor of international commercial law and is also the founder and co-director of the University of Nottingham Commercial Law Center. Since 2006, she has been an expert advisor to US delegation to UNCITRAL. In 2013, she was also appointed senior counsel to the World Bank. In her capacity, she has also advised governments of some 10 countries in Africa, Asia, Europe, Caribbean, and so on. She has also worked on reforms of business, personal insolvency, credit debtor system. And finally, as the moderator today, we have Dr. Professor Risham Garg from the Center of Transnational Commercial Law, National University, Delhi. With this, I would hand on the mic to Professor Risham Garg to start the session.
Right. Thank you. Thank you, Oshika, for the kind and generous introduction to all the eminent panelists. Yes, Mr. Som Shekhar has also joined. Welcome, Som. I believe we should start the session by inviting our guest from UNCITRAL, the Senior Legal Officer, Kate Lannan, to provide her opening remarks on cross-border insolvency.
Thank you very much for that kind introduction and for the introduction to speak with you today and to be part of this wonderful event over yesterday and today. And congratulations to not only the organizers, but also to fellow supporters. As you know, UNCITRAL is one of the strong supporters of this event over the past couple of days. Now, I understand that Oshika has promised to share my presentation. So I hope that it's possible to share it.
Yeah, just give me 2 minutes. I'll share it on the screen.
Great. Just to kick off, as you know, UNCITRAL is the UN Commission on International Trade Law, and we are based in Vienna, Austria, in the Vienna International Center. I have a nice photograph of it, which we'll see on the screen in a moment. Now, as a UN body, when we are deliberating on and adopting UNCITRAL texts, and particularly insolvency texts, what we're talking about today, the entire UN membership, that is all member states of the UN, are invited to participate and contribute by sending delegations. So they participate in our deliberations as either members of UNCITRAL or observers of UNCITRAL, but they have the same opportunity to present their views. We also invite other intergovernmental organizations to send expert participants, and non-governmental organizations that are expert groups of stakeholders in insolvency generally and cross-border insolvency are also invited to participate. Yes. So we do have, UNCITRAL has a long history of work in insolvency law and in cross-border insolvency law. Now, the main thrust of this work began in the 90s, actually, as a result of various events that have taken place globally, but a general recognition that some effort to harmonize the law of cross-border insolvency was necessary in order to take advantage of to ease disruptions in a cross-border sense, to achieve certain aims of cross-border insolvency. Maybe I can share it if it's not quite working.
I'm having some difficulty with sharing it. Could you share it for now?
I am trying to see if I can share my entire screen. No, don't want that. I want to share this. Can you see that? No. Sorry. Share your screen. Somehow it is not working here either. Sharing blocked by my browser. Oh, that's interesting. Try that again. Okay. Well, unfortunately, my browser is blocking the sharing, and yes, so we're not able to share my presentation, but I'll just speak generally, and maybe the presentation can be shared with you later. So coming back then to the general insolvency text that UNCITRAL has prepared. We have the legislative guide on insolvency law, which really sort of is contains a wealth of information on all aspects of insolvency. And I really encourage those of you who are interested to visit our website and to have a look at all of the resources that we have. Now, today we're talking mainly about the UNCITRAL model law on cross-border insolvency, and I'll refer to this as the MLCBI. You should note that the Guide to Enactment and Interpretation of the MLCBI is also available on our website. We're also quite well known for two more recent model laws that have been adopted by UNCITRAL, being the model law on the recognition and enforcement of insolvency-related judgments, as referred to a moment ago, and also, more recently, the model law on enterprise group insolvency. And again, more information and the guides to enactment for all of these instruments can be found on our website. We do have a lot of other resources supporting the understanding and implementation of the model law in cross-border insolvency on the website. And again, interested people should really have a look and see what's available there. But one particular tool of which you may not be aware is called Case Law on UNCITRAL Texts, or CLOUT. And what this consists of is a search mechanism, a searching tool on our website, where you can search the MLCBI article by article and see what sort of jurisprudence has arisen and has come up on with respect to each article, such as we have it, on our website. So this is a really useful tool to see how interpretation has proceeded. And you should know that the digest of case law on the MLCBI has been completed and is currently in translation. We hope it's going to be available later this year, but as soon as the English version is copy set, etc., we will upload it as an advanced copy so you can have a look at that as well. And this will provide all of the jurisprudence on various aspects of the model law as we know to date. Now, the model law on cross-border insolvency to date has been enacted by 51 jurisdictions, which includes 48 states. So 51 jurisdictions, and that's as of December 23rd, 2020. Now, if you had my slides, or when you get access to my slides, you'll see the list of countries there that have enacted the model law. And you'll note that it is definitely a growing list. And we do hope that we will be adding India to this list very soon. You'll also see, when you have access to the slides, that there is a slide that indicates graphically a map of the jurisdictions that have now enacted the model law on cross-border insolvency. Now, my use of the date December 23rd is deliberate because on December 24th, Brazil, which is a very important economy in Latin America, of course, and globally, enacted the model law on cross-border insolvency. We are in the process of ascertaining whether that enactment is sufficiently close to the model law as it exists to ensure that it is an appropriate enactment of the model law. And we anticipate that we will be adding Brazil to this quite long list of countries very soon, and to shading in Brazil on the map as well. Now, just a word, since it is a model law, of course, as with all model laws, the closer that a country stays to the text of the model law, the greater the overall cross-border harmonization effects are, and the greater positive effects there are. So it's quite important to stay, and UNCITRAL recommends that countries stay as close as possible to the text of the model law when it's enacting provisions. So what are we talking about when we're talking about cross-border insolvency? These, of course, are cases in which the insolvent debtor has assets in more than one state, so not just limited to the receiving court or the enacting state, or when some creditors of the debtor are not from the state where the insolvency proceeding is taking place, or where insolvency proceedings concerning the same debtor have commenced in more than one state. So these are situations that we term, or that are included as situations of cross-border insolvency and are covered by the model law. Why should an insolvency law address cross-border insolvency? Now, generally speaking, there are a number of reasons, and these are articulated in the model law as well and in the various jurisprudence, but having the cross-border insolvency included in the domestic law provides for greater legal certainty and predictability for trade and investment, of course, and provides fairness in terms of protecting the interests of all creditors and other persons interested in an insolvency, and the interests of the debtor as well. In addition, and really importantly, these sorts of laws protect and maximize the value of the debtor's assets wherever those assets are located. So not only in the enacting state, and these kinds of provisions can facilitate the rescue of financially troubled businesses and thereby protect investment and preserve employment in the longer term. And of course, it is also important for, in many states, for there to be a specific legislative mandate for cooperation between courts and other competent authorities, like the foreign representative. Now, the scope of the model law, it applies to foreign proceedings relating to insolvency. Now, the proceedings have to relate to insolvency, and this is articulated in the definition section of the model law. In addition, the purpose of the proceedings has to be the reorganization or liquidation of the debtor. The proceedings have to be collective, so not really just focusing on an individual creditor or group of creditors, but collective as regards the debtor as a whole. And the assets and affairs of the debtor have to be subject to court control or supervision. There are actually 4 key elements to the model law on cross-border insolvency. These are access, recognition, relief, and cooperation and coordination. So I will very, very quickly go through some points on this. So when we talk about access, we're referring to who has standing in the receiving court to initiate an action for recognition of a foreign proceeding and to request assistance. These access provisions allow foreign representatives and creditors to commence and or to participate in local insolvency proceedings. And the access provisions in the model law address the formalities that have to be satisfied and establish certain evidentiary presumptions in order to ease that access and to check the box on the formalities. And the access provisions, of course, also authorize the courts of the enacting state to seek assistance abroad for local insolvency proceedings. Now, the second pillar is recognition. In the recognition section, we have the establishment of clear and straightforward conditions for recognition, again, without unnecessary formality or procedure. And if those particular conditions are satisfied, and they're all specifically laid out in the model law and further articulated in the other supporting documents that we have dealing with the model law, then the result is certain and predictable, and either recognition will be granted if those conditions are met, or if they are not met, it will not. And there again, there are certain presumptions as to the authenticity and accuracy of documents that are set out in the model law. Now, the model law, or the recognition of the foreign insolvency proceeding, the enacting court will recognize it either as a main or a non-main proceeding. And there are certain aspects of relief and other elements that attach to whether it is recognized as a main proceeding, a foreign main proceeding, or a foreign non-main proceeding. A foreign main proceeding, a proceeding will be recognized as a foreign main proceeding based on the COMI provisions. So that is the center of main interest. And again, there's much more information available that sort of articulates what that is, or if it's if a proceeding is recognized as a non-main foreign proceeding based on the basis of establishment, again, which is very clearly articulated in the model law and supporting documents. And then, of course, the relief provisions are based on whether the proceeding is established as is recognized as either main or non-main. And there are three main types of relief that are granted, and I think these will be dealt with a bit later. Finally, the fourth pillar is coordination and cooperation, and I think these concepts will be dealt with a bit later in greater detail as well. So I will leave it there. Apologies for being unable to share the presentation. There it is now, sorry. So happily it was able to be shared. However, I look forward to the rest of the discussion, and apologies for that glitch in terms of the sharing of the materials. Thanks very much.
Thanks, Kate, for that lovely presentation. Apologies from our side, because this is a technical glitch. These things do happen. But again, this is we all say it's a new normal. It's all occupational hazards now. So with this, I invite Professor Edith Mevorak to present her topic on the Insolvency Judgments Project.
Thank you very much, Dr. Risham, and thank you everyone for inviting me to participate in this interesting virtual conference. And thank you, Kate, as well for this brief but very clear presentation on which I will build. So, Oshika, we can straight away move to the next slide. And so, in addition to the model on cross-border insolvency, which Kate has just presented, the MLCBI from 1997, more recently, Ancitral adopted two additional model laws to complement the MLCBI. In 2018, the model on recognition enforcement of insolvency-related judgments, and in 2019, the model on enterprise group insolvency. And I will just focus in this very brief presentation on the MLEJ, the model on recognition enforcement of insolvency-related judgments. And this presentation is largely based on this paper that is mentioned at the bottom of this slide. Now, the model, keep showing the previous slide. I will tell you when to move between the slides. Sorry, Yoshik. So the model, the MLEJ was adopted by Ancitral, but not yet by any country. But countries have started considering whether to implement the MLEG, the Model Loan Recognition Enforcement of Judgments. And in the presentation, I will try to highlight the importance of this new model law, but also to show some of the challenges in implementing the MLEG in legal system. And before proceeding to the next slide, just to also say that I was involved in the development of these newer model laws as a UK delegate to ANSI trial and previously as a World Bank delegate. But what I say here and in this article is my own view. It is said in my personal academic capacity. Next slide, please. Next slide, Oshika. Thank you. So first, a general reminder, why at all do we need international instruments for cross-border insolvency? Kate explained very clearly what is cross-border insolvency and cross-border insolvency proceedings. Why do we need international insolvency instruments for them? Because in order to promote a fair and efficient cross-border insolvency process that maximizes the value for the enterprise that has elements in different countries, assets, subsidiaries, branches, creditors, we need cooperation, and we cannot just rely on voluntary cooperation, including because some countries may require a statutory basis for cooperation, but also because cooperation may not be sufficient in order to maximize the value for of the enterprise for the benefit of all the stakeholders. We may want to avoid the opening of multiple proceedings and centralize the process in one or few jurisdictions, and then support that global collective main process through recognition, relief, and assistance by the other countries and courts where the enterprise has assets, creditors, subsidiaries, branches, etc. And that is in line with the norm of modified universalism that require that we centralize the proceedings as much as practicable, subject to safeguards. And that can be achieved through a harmonized private international law rules concerning jurisdiction, applicable law, enforcement, assistance, relief, and that can be achieved through international instruments. Next slide. And ANSI trial responded quite brilliantly to this need in the late 90s when it developed the MLCBI, the Model on Cross-Border Insolvency that Kate presented, which was adopted in 1997 by ANSI trial and since then by many countries. It provides provisions on cooperation, but also it supports that concept of centralization by requiring that countries recognize mainly a main proceedings that is opened at the center of main interest at the COMI of the debtor, and that recognition results in certain automatic relief, and courts can also grant additional discretionary relief. It is also allowed under the MLCBI to provide certain support to non-main proceedings where the debtor has an establishment, and all this is subject to safeguards to ensure that public policy isn't breached and that creditors are adequately protected. But the MLCBI didn't harmonize all the private international law aspects of insolvency, and specifically, it did not include explicit specific rules regarding the recognition and enforcement of the insolvency judgments of the foreign forum. Still, it is potentially possible to cover this issue within the MLCBI, specifically within the MLCBI discretionary relief provisions, which are potentially quite broad, and indeed various courts around the world have applied the MLCBI relief provisions in this way in order to also recognize and enforce insolvency judgments of foreign proceedings. But not all courts follow that approach. And famously, the United Kingdom Supreme Court, in the case of Rubin versus Eurofinance, refused to recognize and enforce any insolvency judgments of the New York main proceeding court, considering that the MLCBI does not address enforcement of judgments. And other courts as well in Japan, in South Korea, followed a similar reluctant approach to apply the MLCBI in such a broad manner. Next slide, please. And so Ancitral, working with 5, which deals with insolvency issues, decided to take this issue on board to address this gap, to resolve that uncertainty, and developed this MLIJ, Model Law on Insolvency Judgments, which now provides specific definitions regarding the meaning of insolvency-related judgments and the procedure for seeking recognition and enforcement of insolvency judgment, the specific safeguards that apply in this respect, and the jurisdiction basis for recognizing or refusing to recognize and enforce insolvency-related judgments. The MLIJ also includes, at the end of the instrument, in Article X of the MLIJ, a clarification that the MLCBI does include in its discretionary relief provision the possibility of enforcing recognizing and enforcing insolvency-related judgments. And so the MLIJ complements the MLCBI, but it also overlaps with it to some extent, where the MLIJ clarifies that the MLCBI already covers the issue of enforcement of insolvency-related judgments. And so that creates some challenges, some difficulties in implementing the MLIJ in the legal system, because we now have 2 separate instruments, the MLCBI and the MLIJ, that both cover the issue of enforcement of judgments. And these model laws, these 2 instruments, are not entirely consistent. Next slide, please. There are 2 important differences, and I'm simplifying it here, conscious of the time, 2 important differences between the MLCBI and the MLIJ regarding relief and enforcement. One is that enforcement under the relief provisions in the MLCBI is discretionary, because it is part of the discretionary relief provision in the MLCBI, while enforcement under the MLIJ is mandatory. Both instruments, enforcement under both instruments is subject to safeguards, but the safeguards as well are not entirely the same. And secondly, the jurisdiction basis for enforcement under the relief provisions in the MLCBI are COMI, mainly COMI, the existence of center of main interest or the existence of an establishment, while the jurisdiction basis for recognizing or refusing to recognize and enforce judgments under the MLIJ do not explicitly mention COMI or establishment, but rather they refer to the more general private international rules regarding enforcement, so referring to submission or consent to the jurisdiction, or generally to other jurisdiction bases recognized or that are not incompatible with the law of the recognizing state. So the MLIJ jurisdiction bases are more general, less harmonized, and less insolvency specific. Next slide, please. Still, how can we implement the MLIJ in our legal system while avoiding inconsistencies with the overarching general model on cross-border insolvency, the MLCBI? Well, in my view, we should do so against the backdrop of the general key objectives of cross-border insolvency, as was also mentioned by Kate, and in line with the norm of modified universalism, supporting a main global collective process. Now, we can do that by implementing the MLIJ separately from the MLCBI and then deal with the inconsistency as we go along through the practice and the experience. But ideally, again, in my view, and Kate may think differently or others may think differently, in my view, it would be preferable to try and integrate the provisions of the MLIJ into the overarching MLCBI regime, to merge the instruments and integrate the provisions of the MLIJ in the MLCBI. At the least, what we can do is give effect to that Article X in the MLIJ and clarify explicitly in the MLCBI that its relief provisions include the recognition and enforcement of insolvency-related judgments. We can then also add those specific definitions to explain in the MLCBI what is the meaning of insolvency-related judgments, and to include the provisions regarding the procedure for seeking enforcement of judgments. We can also take another step and go beyond Article X to make enforcement mandatory relief, not only discretionary, but also mandatory relief, subject to safeguards, and the safeguards as well need some alignment. And finally, it would be preferable to also align and adjust the jurisdiction basis, and importantly, to explicitly note that when the judgment is granted by the main proceedings where the debtor has its commi, then that is sufficient, and that judgment should be recognized and enforced only subject to those limited safeguards under the MLCBI, namely public policy and adequate protection. Next slide, please. Final slide. This way, we will make our cross-border insolvency framework more complete and also promote compliance with the system by avoiding vague rules within the instruments that can result in more territorialist approaches. Still, there will be gaps and additional steps to take. We need more countries to adopt all the model laws, the MLCBI, the MLEG, and also the model on enterprise groups. And ANCITRAL also need to address another very important gap in its system, and that is the absence of harmonized rules concerning the applicable law in insolvency proceedings. And this issue is closely related to the issue of enforcement of insolvency judgments, because when a court enforces or asks to enforce an insolvency judgments of the foreign court, it indirectly gives effect or differ to the law of those insolvency proceedings. And so in the absence of harmonized agreed rules regarding applicable law, the result could be that courts will continue to be reluctant to enforce insolvency judgments as well. Thank you very much.
Thank you, Professor Edith. That was really a very, what can I say? I mean, enriching, exquisite, enriching presentation. So both of our first speakers, this was really erudite presentation, and for the benefit of our viewers, I will just explain in a very few simple words. So we are aware about the New York Convention on Enforcement of Arbitration Awards, and that is what is the international legal regime to enforce arbitration awards. There is also a movement, international instrument for recognition and enforcement of civil judgments. Till now in India, we have some mechanisms under the CPC how to recognize and enforce the foreign judgments. Now, similarly, for insolvency also there is an instrument which is being deliberated upon, which is the MLIJ, the insolvency judgments. Now, before moving on to Dr. Kokila, I would, maybe if I can ask both our first speakers, Kate and Irit, just two issues here. So there are, these three instruments. First, model law on cross-border insolvency, and now the two model law on enterprise groups, and now insolvency judgments. And another forthcoming, which is the applicable law. So let's not talk about the applicable law one, but at least we have these two new instruments, the enterprise groups and the insolvency judgments. So do you suggest and propose on the basis of whether there should be one legislation which should be drafted, which can be drafted by a state with three parts, or do you suppose and suggest these three model laws can be enacted in three different ways? I mean, be kept separate. I mean, you may choose to ignore, but I was just thinking it's not slightly complicated. I'm sure you must have been deliberating a lot in those forums.
Well, I will. I'm sure Irit has a view on this as well, but I can tell you that from the UNCITRAL perspective, we're actually in the process of, well, first of all, it's of course the choice of the state, what the state wishes to do. And in some cases, it may be that, work on implementing the model law on cross-border insolvency, which is really the backbone of the three model laws, more or less, is so far advanced. And that, if you're on the cusp of implementing it, I would say that it probably makes sense to go ahead and implement that. Having said that, there is a way, of course, to, shall we say, entwine or further intersperse the model law on the enforcement of recognition and enforcement of insolvency-related judgments into the model law on cross-border insolvency. And then, of course, the enterprise group's model law is slightly different as well, and probably not as easy to sort of intertwine. I should tell you that the Secretariat is working with certain experts on coming up with some guidance for states on whether or not, on how they wish to proceed. It is possible to do them all at once. It is possible to do them as separate chapters, or it is possible to sort of intertwine them into one integrated and comprehensive approach, but it would depend on what the state wants to do. And of course, UNCITRAL and other experts are available to sort of help out. And I will pass the baton to Irid, who I'm sure has views.
So can you hear me, Risham?
Yeah. Loud and
So
clear.
my first reaction is first of all to adopt the model laws in whatever way. I mean, the simplest way would be to just adopt them as they are, and it will be a very good step. If you take the more arduous approach to try and make full sense of how those model laws interact together, that will be preferable in my view. And specifically, I would consider the model on groups and the model on judgments differently in this respect. And Kate sort of suggested that as well briefly, where she said the model on groups, it may be more difficult to merge it with the MLCBI. I would also say that it may be less important to merge it with the MLCBI. I think that the model on enterprise groups is a standalone, separate document, separate instrument that builds on the MLCBI, but it focuses on enterprise groups. And you can safely, in my view, just incorporate it as an annex or a separate chapter or a separate instrument, in addition to enacting the model on cross-border insolvency. And already you will be in a very good position internationally if you do that. Now, the model on judgment is slightly more difficult because of what I said. There is an overlap there. There isn't an overlap with the model on groups. There is an overlap between the model on judgments and the model on cross-border insolvency because both address relief, including enforcement. And that's why you need to take this additional step. And my advice would be to do that carefully. It's not so complicated, but it's possible to do that carefully and based on the guidance that UNCITRAL will provide. And I'm happy to assist. Thank you.
Right. So thanks. Now, two issues I maybe want to address to Som. In your presentation on insolvency judgments, I'm sure there are a lot of provisions, but two aspects struck me, which I think would be of interest in India for the litigators. One is the sort of a mandatory implementation and adoption of the insolvency judgment, which I do believe is not inconsistent with the rules of private international law. For civil judgments as well, we have similar provisions, barring a few norms on public policy and some others. Generally, foreign judgments are also mandatorily adopted. Now, other question was on specific relief. So specific relief is generally discretionary. However, if I understand correctly, under the insolvency judgments model law, it appears that it will also be like a mandatory, which can be ordered by the foreign court. And so is this what I understand correctly? So if Som understood me correctly, if you have any views on this question now, or maybe we can ask your views at some later stage. Som, can you hear me? Mr. Sundareshan, Somshekhar? Not sure. So anyway, so what I'll do is I'll text this question to him, and first let's Yeah, I think maybe we can start with the presentation by Dr. Kokila Jairam now. And in the meantime, I will try to connect with Som and we'll seek his response on some of those issues. So, Dr. Kokila Jairam?
Uh, uh, could somebody confirm if I'm audible?
Yes, yes, you are perfectly audible.
I'm just sharing my presentation. I hope the presentation is visible.
Sure, it's coming up. Just, I think, maybe another 10 seconds.
Okay. I hope there's been some problem.
Yeah, it's on now. We can see it.
It's on?
Yeah.
Thank you so much. We've been facing difficulties in connectivity through the afternoon. So, if you can bear with me for a minute. Okay. A very good evening to all my fellow panelists and all the participants today. Today I have a very small presentation on how a country might choose its cross-border insolvency regime. This presentation and my talk in the next couple of minutes is based on a paper that we did for the annual publication of the board last year on assessing how the ancestral model law fits for India, and should India be looking beyond the ancestral model law to deal with its cross-border regime. So I've kind of generalized the presentation for other countries, if other countries are looking at how to deal with it. Deal with the question of choosing a cross-border regime. Moving ahead. There are basically three questions that one would like answered when we are looking at choosing a regime. One is, does at all a country need a cross-border insolvency regime? And if it needs one, then what is the form, content, and substance of such a regime should look like? And if we have chosen the form of the regime, then when, at what point in time can this be instituted? So we were looking to answer these questions for India. And I think the case for India would be as relevant for other countries as well. So we were able, through our assessments, able to answer the first two questions to some satisfaction. But the third one, I think the question of timing is still yet unanswered for us and for India at least. Okay. To answer the first question, we have to understand that there are some parameters that we need to think as prerequisites for a country to actually think of putting in place an insolvency regime. First one, of course, the integration of the country's economy with the global economy, assessed through its flow of capital, trade in goods and services, the movement of people, labor, and the existence of multinational businesses. And the second part, this from the real sector, and the second part, the financial sector, because the entire credit system becomes increasingly integrated as a country opens up. So on the financial sector also, the maturity and integration becomes important for us to determine the need of a regime. And similarly, the maturity of legal systems in place in the country, and especially the kind of insolvency laws that already exist in the domestic front. None of these parameters are static, so the future outlook on these fronts is important for a country to take a call on whether a particular regime of cross-border law is suitable for it or not. So going through the next couple of slides, our assessment for India is, of course, India is more integrated with the global economy now than it was a couple of years back. We are seeing increasing flow of investments, especially in greenfield projects in the manufacturing and services sectors. India's trade has been growing, and you would also see that 80% of India's trade is supported by some form of credit, guarantee, or insurance. So, and this credit comes from banks, both Indian and foreign. So that's important when we are talking about insolvency regimes and cross-border claims. And roughly 5.2 million Indians were working abroad. So I think we are more integrated than ever before. But in terms of thinking of the future, I think in the future also one would look to a point that that integration is growing. But then there are doubts in which direction we could move. And in terms of India's financial system, here again we've matured to a large extent. India's capital markets have become comparable to the advanced economies in terms of efficiency, tradability, resilience, and stability. So I think you can see the numbers show that the outstanding stock as of March 2019 are all pretty high up, and the markets are still growing. And banks in India's financial system have been crucial both to economic and social progress in the country. We have about 95 lakh crores in gross credit in the end of financial year 2019. And Indian banks and their participation in foreign jurisdictions has also increased. The BIS data shows that the corporate private sector claims, foreign claims in India is roughly around USD 33.5 billion. So a substantial amount of these would come in as cross-border claims if they were to be insolvency in these multinationals. And similarly, India's legal system, of course, after the 2016 institution of the Insolvency and Bankruptcy Code, I think the entire ecosystem has been reformed and almost done with a fresh slate. And the ecosystem around the code is also strengthening from by leaps and bounds. And Mr. Somashekaran is here. The Insolvency Law Committee has already recommended the adoption of model law to the government, and we are also seeing, on the other hand, that Indian origin companies are also increasingly become multinationals. The RBI census showing that more than 20,000 companies have invested abroad, and at least 70% of these is going into 6 specific countries. So if India was looking at having an insolvency regime, I think the access to these 6 countries, or probably an extended list of another 7-8 countries added to this list, would be targeting for. Moving ahead, as of now, India has 4 options, to which Mr. Rishabh just earlier mentioned that the Code of Civil Procedure does provide options for executing foreign judgments and enables Indian courts judgments to be executed abroad. And the second set of instruments, protocols for cross-border insolvency, the adjudicating authority under IBC, the NCLT and NCLAT are now using protocols in the Jet Airlines case. So it is an ongoing case, and we are looking to see how this instruments pan out in enabling the resolution of the Jet Airlines case. And then the code, as of now, provides for specific bilateral arrangements on a reciprocal basis between countries to take forward cross-border insolvency resolution. And of course, the next is the unsettled model law. So the options for us is whether should we strengthen the existing options or should we go ahead and choose a new one and learn to adapt ourselves to a newer set of laws. So if we look closely at examining these options, the CPC is not so enticing, because then you would have to go back into depending the already burdened judiciary in India, and the existing limitations of the system would again creep in. In terms of protocols, the issues are that we do not have previous experience in dealing with protocols, and we are mostly relying on the judiciary to take a call and some learning from other international experiences. And of course, we are also assuming that there will be cooperation between all parties in a protocol so that these successfully bear fruit. And the other two options, those are the new options that we had. One, the bilateral arrangements that has been provided under the code, or choosing the model law. Now, bilateral arrangements, of course, India has some experience with purpose-specific arrangements for trade, for investments, for other mutual legal assistance. And if we are to choose this bilateral arrangement, like we earlier identified, India has really close ties and a lot of multinationals working across at least 15 other countries. So we would have to negotiate a document with a treaty with these 15 countries to begin with. And then there would also be the challenge of designing a model document which can customize across the other regimes in these 15 countries. So that's the challenge with bilateral arrangements. But of course, the model law seems like the best option because it comes highly recommended, and India has been part of the commission while the model law has been drafted from its initial stages. So the questions of legitimacy would be addressed already. And since most of our countries with which we have good ties, and we would think of prioritizing, or have already adopted a version of the model law, though some of them are still left out. And of course, there's a lot of flexibility that the model law allows. But they also the pitch side of this is that different countries seems to have chosen different customization of the model law. And again, there are other concerns which, of course, earlier speakers pointed out. So I will not dwell much on that. So given these set of options that India had, I think the biggest choice has fallen for the model law. However, we are still to think about the timing of getting the model law in, and I think there are second thoughts. There could be second thoughts about the future because multilateralism is waning, and on the one hand, and the other hand, after the pandemic, of course, there are predictions that insolvencies will increase, and of course, with these, some of cross-border issues will also be increasing. So the choice of putting in place a cross-border regime, I think the time has come. But in institutionalizing the model law or the bilateral arrangement, how much of benefit will come from one of these options, I think these questions remain to be answered. So I think with that, I would stop sharing my presentation. I hope I was audible throughout, and if there are any questions or... Any views?
Yes, thank you, Dr. Jairam. That was very, very lucid and explanatory presentation, and that clearly explains the concerns. Certainly, I do believe that our experts would certainly agree that post the pandemic there will be an influx. There are certainly several insolvencies, and any country at this stage must take their time to adopt. Certainly, it's not a question that we will or we will not. I'm sure that the ILC committee has already recommended the adoption of the model law, so it will be adopted. However, it's just the timing. Apparently, our even I believe our UNCITRAL experts might be able to agree that timing might not be suitable. However, I'll now ask Mr. Som to provide some of his comments. I hope he is here. Som. Okay, so I think he just again got. Let us see. Som, have you joined in? Yeah.
Yeah. Are you able to hear me? Am I audible?
Yes. We are able to hear you. Please.
Okay. Thank you so much. I'm unfortunate we're having these technical glitches. I'll be very brief and specific in terms of some comments, and then leave it to a interactive discussion thereafter. The presentations before me were pretty lucid on the concept. I just wanted to give a quick update on where we are in India on some of this. In 2018, the Insolvency Law Committee recommended the adoption of the UNCITRAL model law, and in fact translated a set of recommendations into what would be Part Z of the Insolvency Bankruptcy Code. And currently work is underway on drafting subordinate law, leaving it to regulations to deal with operationalizing coming on board with the UNCITRAL model law for India. When as a practitioner, I thought it would be interesting to give an example of how this played out in a real life recent situation. I mean, this is true for shipping companies and airlines companies, which literally have cross-border operations without necessarily having limited liability entities in each jurisdictions that they do business in. So take the example of Jet Airways in India. We had a very interesting situation where a Dutch court took cognizance of insolvency proceedings being initiated vis-a-vis some Dutch creditors. And the professional from there, the administrator, came into the Indian tribunal seeking recognition. And in the absence of guidance, at the first instance, the recognition was denied. It was an appellate forum that eventually worked out the arrangement between another insolvency proceeding initiated in India and the resolution professional in those proceedings to interact and engage with the administrator in Netherlands. So that's a live example of what happens when there is an absence of predictability. Therefore, there's a very keen need felt to adopt that, and work is underway as part of the committee. I can say that we're now looking at taking it to the next level and getting it implemented in India. But I just thought 4 broad thematic points I should leave behind for issues for consideration. One is, of course, the very facet of access, as to how do we allow access and how do we enable access to administrators and resolution professionals from outside India to resolution proceedings in India. The second thematic issue I wanted to tap about, because the model law is model law, we just need to adapt it and make it work practically in a federal multi-state jurisdiction like India. Fortunately, unlike the United States, we do not have state laws for corporates and state law for insolvency. That's at a federal level across India. But it would get even more complicated if there were to be variations in insolvency and variations in corporate law across states, particularly if we are looking at concepts like the special economic zones or the gift city, where the intention is to deviate from federal law to the extent the constitution permits. So this is another area of futuristic consideration that we need to have in mind, particularly if economic activity in such special zones goes up, leading to the need for coordination as if it was cross-border, even within the territory of India. Then the issue of COMI is something that we grappled with significantly in terms of timing as to when should one determine the question of COMI. At what point should it be determined? The recommendation has been to determine it at the time the initiation of insolvency is done in the foreign jurisdiction, rather than at the time when the application for recognition is made. Much can turn on these two, much need not turn on these two, but in peculiar facts and circumstances, providing certainty would be very, very useful. And therefore, to bring a degree of predictability and certainty, in India, the path being taken is to determine COMI at the time when the proceeding is initiated in the foreign jurisdiction. The other element I wanted to leave behind is to talk about whether the foreign proceeding is a main proceeding or a non-main proceeding is going to be a subject matter of a lot of controversy and debate. So the current thinking is to provide indicia for courts to determine that, and we would like being a common law country, we would like some element of stabilization through the judicial process, appreciating these concepts and allowing case law to develop. And towards that end, akin to the GIN guidelines, some sort of soft guideline-based provisions for coordination and cooperation across courts is again something you will see from India. A couple of elephants in the room. If we are prone to suspending our bankruptcy laws, like we have done in the course of the pandemic, what implication will it have in a cross-border recognition where other jurisdictions have not suspended it, but we have suspended our law in terms of initiation? Is a question to think about. Is it at all necessary to suspend it in the wholesale manner that we've done, or does one need to structurally modify it as some other jurisdictions like the UK has done? Is something to think about and introspect very deeply. The second point I wanted to touch upon is to ensure that capacity building across tribunal benches needs to be made uniform. This is not a law which you should say is a specialized activity and it should go to a specific bench of the National Company Law Tribunal. If we were to do that, we would complicate things enormously. This is therefore very important to ensure that the understanding of cross-border insolvency principles is uniform across benches around the country, regardless of whether the bench is in a commercially intense state or not. This is something to be borne in mind. Finally, I just wanted to say that we do need to think about enterprise level insolvency in far more detail for cross-border insolvency to meaningfully work. Because if we look at the entity level resolution and not at enterprise level resolution, unless that problem is harnessed, the efficacy of really having a cross-border insolvency framework that truly works commercially would remain undermined. I think I'll stop there. I thought I'll leave these broad points out there on the table so that we can have a discussion from here. Thank you.
Thank you, Som. Before taking further discussion, we have along with us Judge Leonard Rich. He's retired bankruptcy judge from the U.S. bankruptcy courts and currently dean at the Norman Wiggins School of Law at the Campbell University. He has decades of experience as a bankruptcy court judge and now in academics also. So we would like to hear his perspective on the bankruptcy courts in US during the times of pandemic and post the pandemic. Over to you, Judge Leonard Rich. You are on mute. Please unmute yourself.
Can you hear me now?
Yes, we can hear you loud and clear.
All right, thank you. Well, good morning from Raleigh, North Carolina. I'm in my office at Campbell Law School, where I'm in my 8th year as the dean. And I'm delighted to join you here, what for us is an early morning. Although I must say I'm a bit distracted this morning. Like most thoughtful Americans, I've barely slept since the horrific events in my country yesterday. We're all stunned and sickened and trying to figure out how it happened and what our way forward is. But that said, I did leave the bankruptcy bench 8 years ago, but I was there for 21 years, including a 7-year term as the chief judge of the bankruptcy court in North Carolina. And I'll always be proud to call those judges my colleagues, in part because of the intrinsic interest and importance of the work, and in part because of the rigorous merit selection system through which bankruptcy judges are chosen in the United States. I firmly assert that in terms of intellect and caliber, it is one of the strongest benches in the world. If you don't believe me, ask the staff at the Federal Judicial Center, who trains all of the judges in the United States. And since our chapter 15 codifying the model law was passed in 2005, and in my view is about the only good thing that came out of that piece of legislation, we are proud of the role that we have played in developing that jurisprudence. I don't have the 2020 numbers yet, but from 2005 to 2019, we saw almost 1,500 Chapter 15 cases filed in the United States, many of them major and precedent setting. One of the characteristics of our dockets are their fluctuation with economic times and the resilience required of us to respond. In 2009 and 2010, when my caseload more than doubled and I was in court 10 to 12 hours a day, I and my colleagues did it without any complaint. If the bankruptcy process does not move efficiently, it loses most of its efficacy. We are not a court where matters can just be taken under advisement at our leisure for long periods of consideration. In fact, in those days, I always felt like I was dealing poker cards and calling the winners as I saw them. In talking about the bankruptcy courts post-COVID, I admit we're a bit puzzled about why the surge we anticipated has not happened. Loss of employment and business failure are leading causes of bankruptcy filings, and those are at unprecedented levels. But in fact, bankruptcy filings in our country in 2020 are down about 27% over their 2019 totals. In trying to understand why, many point to the $1.2 trillion stimulus package known as the CARES Act that helped many unemployed stave off bankruptcy. And state and local governments, federal agencies, and companies have enacted policies that have put a temporary halt to evictions, foreclosures, and other measures to ease financial strain. But those cannot go on forever. Virtually every analyst predicts that the surge is coming. The American Bankruptcy Institute predicts that next year, business bankruptcies in the U.S. will increase dramatically, perhaps to their highest levels ever. And some underlying industry numbers support this view. Airline travel is down 70%. Hotel occupancy rates are averaging about 43%. The amusement industry has seen a 98% drop in attendance, and movie theater attendance has dropped by almost 100%. One of the leading analysts says that we will see next year an avalanche of filings by companies with more than $1 billion in corporate debt, because there's been an explosion of debt at this level. And these, of course, are the cases most likely to invoke international insolvency remedies. I spoke with the chief judge of my local bankruptcy court, the Honorable Stephanie Hummerkaus, and her views are helpful. She agreed that filings have been low, but she also believes the floodgates will open in 2021. But she added two interesting points. She says that she has seen a remarkable show of compassion among lenders and hopes that that will continue. And she also reported that her court, like bankruptcy courts nationally, have relied on their superior technology and have operated remotely without a glitch during the pandemic. Another analyst predicts that the average docket of a bankruptcy judge will grow about 150% next year, putting a real strain on the system. There have been some suggestions that a number of the retired bankruptcy judges in the country, about 250 of us, could be called back into temporary service to work through these numbers. And I, in fact, have had feelers if I'd be willing to take a short leave of absence from the law school to return to the court to help out should the circumstances become dire. But we just can't be sure. As Yogi Berra, the famous player and coach of the New York Yankees, once said, predictions are hard, especially about the future. Historically, because the bankruptcy court dockets rise and fall so dramatically, Congress has been reluctant to add permanent judgeships in times of high caseload. They've resorted to the device of a temporary judgeship. The person appointed to that judgeship gets a full term, but the next vacancy on that individual court that occurs more than 5 years later is not filled. Of the 345 authorized judgeships in the United States, it's not a lot of judgeships for a country of over 300 million people. 29 fall into that category of temporary judgeships. Congress has just passed a bill extending the lapse date of 12 of these in response to the pandemic. But I was informed yesterday that for reasons I do not understand, President Trump is not likely to sign it, which will be a pocket veto under our system, and the new Congress will have to start over. And I'm not sure why. Historically, he's been very fond of bankruptcy. He's taken 3 or 4 of his companies through the process and shed millions of dollars of debt while doing it. Let me close by noting that we will have one weapon available to us now that we lacked before, an expedited small business bankruptcy process known as Subchapter 5 that my colleague, Professor Pryor, will discuss later. Now, many of you will be relieved that it does involve a trustee in every case and does not rely entirely on the debtor in possession to run the reorganization process. As I've traveled the world, I've always noted deep skepticism about this provision of our code. I'm frequently asked, what is the justification for leaving the folks who ran the company into the ground in charge of its reorganization? But in my experience, it works well, and for several reasons. First, no one has more of a stake in a successful reorganization because the owners are often having their personal finances tied into the successful reorganization. And corporate debtors are very tightly supervised by our U.S. trustee system. No debtor can take any action outside the ordinary course of business without notice to creditors and court approval. And finally, our Chapter 11 process is largely consensual, and it requires acceptance by creditors. And a rogue debtor is just not likely to obtain that. Well, I see that we are at our time, and I very much thank you for this invitation to participate. I have spent a considerable amount of my career as a judge involved in international initiatives, and I always appreciate the opportunity. Thank you.
Thank you. Thank you, Judge Rich, for that. Yes, we do understand that there were some very unfortunate events yesterday. And it's a blot on the democracy, and even the UN has made some comments. But these are tough times, and any such news is certainly not welcome. But we really appreciate your joining in this session, and I would like to again, offer my certainly, we really appreciate all your support to this symposium. Yes, there are some, as you have mentioned, some measures into the US bankruptcy system regarding the judges, and there are a lot of bankruptcies already going on. Let's see what this year has in store for us, and I'm sure all our experts, professionals, regulatory bodies, they are prepared for any eventuality. I think we just have 5 more minutes. And before concluding, I would like to invite our ancestral expert, Kate Lannon, and Professor Erit to provide their comments on some of the views expressed by Dr. Kokila Jairam and Som. So it's basically, well, even though it's probably a feasible option to. I mean, I won't say it's a feasible option, but maybe their comments on what is the feasibility in case of going into the bilateral agreements and protocols with maybe 10, 15, or 20 countries. But certainly what is required now is cooperation and coordination. So whether we so the question that I had posed inside the scheme of the symposium itself is whether we adopt the model law or not, but we require cooperation and coordination, whether it is achieved through model law or it is achieved through protocol. That is what's required. So what are your comments on that, both of you, Kate and then Professor Edith?
Well, again, I'll just take the floor quickly initially, and I'm sure Irit will have some more details she can add to this. But of course, the model law and cross-border insolvency envisages protocols being established between courts. And there are, in fact, again, not to toot our horn again, but there are a number of resources on the UNCITRAL website that deal with this particular issue, that set out specific protocols. There's a practice guide. There's the judicial perspective, which is another document we have, which provides specific guidance to judges who are trying to work out how they can establish collaboration and coordination. So this is all envisaged in the model law. And just one comment I wanted to make as well is when we're talking about sort of a federal system, I'm a Canadian, so my ears pricked up when I heard this. In Canada, we also have a federal bankruptcy law and the Companies Creditors Coordination Act. And here that's where we have the model law sort of intertwined, and each specific province has a specific company law as well. However, the federal model law, enactment of the model law, is very true to the model law itself, so it didn't affect that. So anyway, I will pass the microphone now to Irit for additional comment.
Thanks. I agree, Kate, regarding federal versus state. When it comes to insolvency, I would distinguish this here between insolvency and company law. There is a difference there, and specifically insolvency, because it requires a collective approach, either on the federal or on the global level. You need instruments on the federal or the global level for insolvency. And that links nicely to your question, Dr. Risham, regarding whether or not to adopt a model law, or whether to opt for a model law or for protocols. In my view, your first step is to adopt the international instrument, primarily the Amsterdam Model on Cross-Border Insolvency, and then in addition, the Model on Judgment and the Model on Groups. And that gives you the overarching harmonized system. Protocols are mentioned in those instruments. Again, primarily in the MLCBI, in the cooperation provisions, protocols are mentioned there. So you have the statutory basis to enter into protocols through the incorporation, the implementation of the model on cross-border insolvency. Also in the model on groups, protocols are noted again as means of cooperation in cases where the debtor has more than one entity, when it is an enterprise group. So the protocols are not sufficient, right? Because the model laws provide for more than just cooperation through protocols, and for more than just cooperation full point. So full stop, sorry. Because as I mentioned, you need in many cases to avoid multiple proceedings and cooperation, and just have a single process with recognition and assistance and relief provided to that main process. Thank you.
Thank you, Kate and Edith, for your very insightful comments, and I'm sure these will be very helpful. For just one last comment, if Dr. Jairam or Som might want to have some final comments before we conclude this session, I think we will just wind up in the next 2 minutes. Dr. Jairam or Som, if you might want to make any last comments.
The cards are open for India, I think. because the courts are using protocols right now, and the committee has given its report recommending the adoption of the ancestral law, and the court itself provides for bilateral arrangements. So I think all three options are open for us to choose from. So which way we would go, I think only time will dictate. And since the pandemic has thrown yet another challenge, and we are also feeling pressure of needing an enterprise group resolution framework, maybe that would hasten our way to choose one of these options at least before we could take a final call.
Thank you, Dr. Jairam. Very well said. If I may add, it's a diplomatic regulator's stance. But yes, it's this year. I'm sure there should be no hurry of engaging into anything. Som, can I have some of your final comments? I'm not able to see him, but maybe I think right. So maybe what I will do is I should thank our esteemed panelists, and I'm sure I really enjoyed it. I mean, this was a very enriching, very lucid session. It was very technical, and I'm sure our participants had a great treat, great experts commenting, and very free, full, frank discussion on this panel. So I really appreciate all the participants for their presentations and deliberations, and I really appreciate all your support to this conference, and I thank all the participants as well. So thank you all, and we'll quickly move on to the next session now.
Thank you very much.
Thank you for joining us. Yeah.
Good day.
Thank you.
Right. So next set of speakers are here. I can see Antonia. Welcome.
Thank you. Can you hear me?
Yes, loud and clear.
Excellent.
Hi, Antonia. Hi.
Hello, Mr. Kumar.
Hello,
How are you?
Hi,
Good.
Kumar.
Yeah.
Hello.
Hi.
Right. So I think Professor Dawn is also here. Let us see. Okay. Then Professor Pryor. Professor Rebecca is here, and where is Professor Douglas? Where is Professor Douglas is remaining? I think just wait. Douglas is also here. Right. All right, great to see you all. Professor Douglas, welcome to India.
Thanks very much.
Okay, so I think Ria, you can start the session.
All right, I'll just start. A very good evening to everyone, to all the speakers on the panel today and all the participants. After an exhilarating day of sessions, we've come to our final session, which is also a special session, because we'll be discussing a very important topic, a very crucial topic in terms of policy making today. And that is with respect to MSMEs, entrepreneurship, insolvency, and digital economy. How all these factors come together and play out, especially in today's changed circumstances. So to discuss this very exciting topic, we have with us today on panel Mr. A.R. Sajid Kumar. He's the Joint Secretary and Legislative Counsel in the Ministry of Law and Justice, the Legislative Department. We also have with us Ms. Antonia Menzies, who is a senior finance sector specialist with the Insolvency and Debt Resolution team of the World Bank Group based in Washington, D.C. Moderating today's discussion with us is Ms. Dr. Risham Garg, who is the Associate Professor of Law at NLU Delhi and the Research Director at Center for Transnational Commercial Laws. Joining us today on the panel is also Professor Douglas Cumming, who is a finance at Florida Atlantic University. We have with us today Professor Rebecca Perry from Nottingham Law University, and she's the co-director of the Center for Business and Insolvency Laws at the university. Also joining us today is Professor Charles Scott Pryor, who's a professor of law at the Campbell University. Prior to Campbell Law, Professor Pryor served as faculty at Regent University School of Law. He served as resident scholar at the American Bankruptcy Institute in Washington, D.C. He was also a Fulbright scholar at NLU Jodhpur and also visiting professor at Handong International Law School in Pohang, South Korea. I extend my warmest welcome to all the panelists today, and we hope to have a very exciting discussion with all of you. May I please call upon Dr. Risham Garg to take the discussion forward now. Thank you.
Thank you, Ria, for those introductory remarks. And without taking any much time, I will straight away invite Mr. Sajiv Kumar to start his introductory remarks for the session.
Thank you, Dr. Garg. A very good morning, good afternoon, and good evening to all of you, all the esteemed panelists. So wish you all, first of all, a very promising and healthy new year. Let's hope 2021 would find out some solutions to our lives, how we'll be able to make our lives easier. Let me first of all thank the National Law University Delhi, especially the Center for Transnational Commercial Law, and all other participants. I have immense pleasure to be here today. When the world over, is thinking about how to revive, how to help, how to handhold one of the most important components of our economy, the MSMEs, in our respective jurisdictions. Of course, it's not only in a country like India. Throughout the globe, MSMEs play a very vital role in the economy. I remember to have heard somebody asking how, in the context of insolvency and bankruptcy code, it is helping the entrepreneurship, while at the same time it is its primary objective is insolvency resolution. I think the very resolution process of the insolvent ridden companies, and reviving the company and getting the company back to business, and then helping and growing the economy itself is the answer for entrepreneurship of that is provided by the IBC. So as I said, it is very critical in the economy. The MSMEs, by virtue of their widespread presence in production, manufacture, providing goods and services, and also in terms of employment generation. Sustainable MSMEs is therefore very important in every economy. In a way, we can say that economy, MSMEs are the backbone of the economy and our economic existence. A thriving, continued and unaffected business by MSMEs during the economic turbulence and crisis situations such as COVID-19 pandemic also assumes very big importance. First and foremost, duty of the state, if I can take it that way, and also the regulators, which is regulating the market, is to keep the MSMEs afloat without getting affected by financial and other crises. So if at all there is any chance of their revival, and it's quick revival and easy revival, and the revival should be made cost effective by the state as well as the regulators. It is our duty to see that the MSMEs are back to their feet as quickly as possible. So here comes the need to have a strong sustainable framework for the insolvency resolution of MSMEs. IBC, if you take as it was originally enacted, had no express provisions to deal with insolvency resolution of MSMEs. Although there was some provision to apply the code to certain threshold of default. Of course, the threshold of default was very low. As you know, Section 4 of IBC provided, which provided only a small, default sum of 100,000 Indian rupees for triggering corporate insolvency resolution process. So the section, of course, left little power to the central government to change this threshold from 100,000 to 10 million Indian rupees to trigger insolvency. So this small default threshold continued for about 3 years since the code was enacted, but this must have helped some small firms also as not as financial creditors but as operational creditors to trigger insolvency. But overall, the effect is not really, not good for MSMEs, and I think that was the reason why, the code was to be amended later. The initial thought of IBC was to have a, very strict and disciplined mechanism, because the idea was not to tolerate even a small default. Of course, a country like India, where we had a high percentage of non-performing assets, it was required at that particular point of time. So we thought that this small threshold would bring about better business and corporate culture. And also it would enable ease of doing business for all the participants, not only financial creditors, but also operational creditors. And we thought it would also help the corporate debtors to come out of a failed business and to start afresh. However, this thought has changed in the aftermath of COVID-19 pandemic, because it has triggered the change of CARP threshold from 100,000 Indian rupees to 10 million Indian rupees. So the thought was not to bring too many tiny businesses having comparatively smaller defaults into CARP, as it would have adverse effects on the already crippling economy. So that's the reason on the 24th of March 2020, the government of India came out with a change in the trigger threshold of 10 million Indian rupees, which is a maximum, of course, permitted by the code as it stands today. So from 100,000 rupees to 10 million Indian rupees, the threshold was changed in order to help many small companies, including MSMEs, from being pushed into CARP. So after the original enactment in 2016, almost immediately after that, in 2018, an amendment was brought in the IBC, to make special provisions to deal with the insolvency resolution of MSMEs. There are two aspects to this amendment. The new section which was added, 240A, capital A, in fact, the first part of the section provides for exemption of certain conditions, which was prescribed under section 29A of the code. Of course, 29A was also brought in 2017 in order to prevent certain promoters and directors who were trying to buy back the company, get back the company, and we thought that it would push many defaulted companies into CARP knowingly by the promoters, and they would try to get it back. So in order to prevent that, section 29A was brought in to make certain persons ineligible to be resolution applicants. But then this appeared to be a little harsher on the small businesses, MSMEs. So in order to ease out MSMEs to be resolution applicants, in order to help them to buy back their own debt-ridden companies, Section 29A was eased out, and then this 240A provided that certain persons who are ineligible, but if they are MSMEs, they could buy back their debt-ridden insolvent companies. So that is the most important part of Section 240A. The other important part is that a special dispensation for insolvency resolution of the MSMEs, wherein the power is given to the central government, the government of India, to exempt certain provisions of the code, any provision of this code, in order to have a special mechanism for insolvency resolution for MSMEs, and also to make modifications in the parent law. Of course, this is a rare kind of power which is given by the legislature to the executive, and this rare power is to be used. I think there is a talk. There is a talk and thought in government circles to bring in a provision which will roll out the benefits of Section 240A, and the government of India may direct that certain provisions of IBC would be not applicable to MSMEs, or certain provisions will apply only with some modifications which can be notified by the government of India. So this extra power may be used in the times to come, and certain proposals have been submitted to the government by the IBC. There was a committee. The committee has also cleared it. Sooner than later, I think we will be able to expect a parliamentary intervention to help the debt-ridden MSMEs. I mean, that will help many MSMEs to deal with the situation that has created by the COVID-19 pandemic. Another measure that the government has taken, the parliament has taken, was to bring in a new provision, Section 10A, to suspend the new applications for insolvency resolution, new applications for initiating CARP for a period of 1 year, starting from the 25th of March 2020. The 25th of March 2020 was the date on which a national lockdown was declared in India. And that date was taken as the start date for suspension of the initiation of CARP, and that will continue till 25th of March 2021. So power was given to extend it for a period of 3 years, and now the last 3-year period is going to end on the 25th of March 2021.